Hello. 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 Hello.
Hello.
Hello.
Hello.
Hello.
16. Page number 2, item number 17 to 34. Page number 3, item number 35 to 40.
Yes. Yeah. All right.
Page number 3, item number 35 to 40. Page number 4, item numbers 41 to 56. Page number 5, item numbers 57 to 74. Page number 6, item number 75, 76. Caption.
But under that caption only it is there, presentation thinking model. Yes.
Page number 7, item number 77 to 92.
Take it up along with the other. We'll see today if it doesn't reach, you mention.
Page
Yes.
number 8, item
Today it
number,
is likely to reach. There is a batch. Yes.
page number 8, item number 93 to 111.
Item number 98.
Along with the other extension.
Page number 9, item number 112 to 126.
124 mirror, so we have to take it in. Item 124. We have to take it in. It is also the extension into.
Take it up along with other extension.
Not right. The chart is the jurisdiction of labor code and the proceedings are going on and no stay was granted. It's September 42. Pending cases coming to labor code are 20th now.
20th November is time is there.
Page number
112.
Opposing the extension, I find the extension. It will be taken up.
So we'll be taking up there is a caption for extension of interim orders. When I'm taking up those matters, I'll take up this also. If need be, I'll extend otherwise.
Last week. Will revive quickly or not? But I'm only giving 4 weeks. And we will finally hear it on 6th. That is the reason why I finally get separate they may not be expected because
We'll see, sir. We'll see in the afternoon.
result in revival of the illegal order.
Afternoon, when I'm taking up the extension of interim orders matters, at that time I'll consider your request, both of your requests. Not at 2:30, sir. They'll reach probably before that itself. So when they reach, whenever they reach. If they don't reach, then at 4 o'clock. Yes.
Page number 10, item numbers 127 to 135.
For illegal apartment challenged by the minister in this case is covered by reservation. But is also filed, I also filed the reply. Everything is agreed on. Illegal apartment.
Third week of November.
127 urgent versus time.
No, sir. Everything will come in the daily list. No matter is going out of daily list. They'll only be going up.
Yes.
So they'll be added to the list.
Plus,
Yes.
Version of the year 2022. Suspension was carried clear from we got regular as part of it.
Would be.
So I was asked about the criminal watch. Only on that we suspended more than 20 months. All the despite readings are completed.
Third week. Take all the steps. Third week. Except lunch motion. All other slips you please give for listing only. You give to her.
more than 8 years. Patient that is reason and expectation. Looking at a patient unless you are in the organization for 5 years.
Third week. Yes.
Motion is for withdrawal. Item number 1, Ramachandra, it is seeking for labor, Sudha.
Yes.
1 to 5, your lordship.
Yes.
1 to 5, it is posted for withdrawal. It is unconditional withdrawal. I have no objection.
Your senior also is mentioning online, virtual.
They said there is a settlement outside the court. We are not aware of that party has not informed.
So what they have said is, the petitioners in the above petition instructed me to take steps to withdraw the above petition. Therefore, I request you to direct the registry to post the above petition for withdrawal. That's all. There is no condition here. No liberty.
May I mention, I'm sorry, your lordship, may I mention one thing, your lordship? So far as item number 6 is concerned, they gave a affidavit saying that we settled the matter out of court, which is not correct, your lordship.
All right. Item number 1 to 5.
1 to 5, they can withdraw.
The learned counsel for the petitioner has stated as under in his letter dated 31/10/2023. Okay. As stated as under, in view of the same, the request is expressed as withdrawn.
6,000.
Item number 6, what is the letter?
Item number 6, your lordship, at paragraph number 4 of the affidavit, they said that management agreed for a settlement out of court and the matter was settled out of court. In fact, no such thing has happened, your lordship. The statement is wrong. What actually they said is they want to withdraw the case because not to pursue the case because of their personal reasons to our office. But now they wrote in the affidavit something else, your lordship. Let my friend delete the para number 4 and let him withdraw. I have no objection.
There is no affidavit filed before me, number 1.
It was
There is a letter given taking simple withdrawal immediately. There is no mention about any settlement.
then your lordship.
The Learned counsel for the petitioner by letter dated 2/11/2023 has stated as under. In view of the same, the petition is dismissed as withdrawn.
Much obliged.
All your cases 1 to 5. Withdrawn, just.
Item number 7, for orders of court, nothing, seeking for general administration.
Anyway, we are going to allow them. I'll directly register to number the IA and then permit you to withdraw the court fee and return you the fund.
Acharya.
Yeah,
Yeah, leave petition.
you're asking to leave to file a CIP and prosecutor says being effective third parties. Oh. Then a notice will have to be given.
There was a partition suit in 2000.
No, in a CRP, in a civil suit where you are not a party, you should have got yourself implicated there.
I have filed a petition, I have stated so.
Hmm.
So what happened is, bill was filed. That was disposed of on merits. They filed a petition to readmit. They report no counter because there is a collusion now. Readmit. Now they filed an amendment petition stating that decree passed by me in 2000 is null and void. That is, in that they say no counter. And I have filed an interim petition. But they are insisting to pass articles in their petition that is posted for tomorrow, my keeping aside my interim petition. Now that article is passed, I will know that. I have filed the interim petition also, 758, 769. I have stated so in last pages. Page number 125.
I'll direct the civil court to consider applications.
Let them consider, let them not pass any answers to the amendment petition. Now in the amendment, they are saying, decree passed by which I have purchased the property, is set aside that. That was all.
They're asking for set aside of a decree in your suit.
Not in the suit filed by the same parties earlier.
Earlier, but you were not made a party.
I was
You
not
are a subsequent purchaser.
subsequent purchaser in pursuance of decree
Hmm.
after shareholders. Now the shareholders have colluded each other. They have filed a separate suit for partition in which they sought for setting aside the decree passed that. They have withdrawn that again. They got deleted. Therefore, that suit was dismissed subsequently. And the suit appeal is filed. Now, appeal was dismissed on merits. Now they have colluded to knock away the property of me, and they filed a petition to readmit the appeal. That was allowed because they report no counter, other side. Now,
I'll issue notice and I'll stay the proceedings.
yes,
Let them come. Yes. Both in IA also, IA 1 of 2022. Yes.
Item number 9, Prasanna Kumar, keep the home.
In the very same set of facts where criminal case is there. Yes, who is appealing? Not same.
First of the because last day that is submission insurance private. The last day as well as the first pair of the
Private business. Yes.
that part not in the FIR is not an accused.
No, I am seeking only the letter.
Let me complete my
No, there may be some other objections which you are not aware.
FIR not is not an accused.
Hmm.
As against him is not he gave this vehicle and some other private person to transport the ganja from Orissa to Hyderabad.
He has given his vehicle on
Vehicle on-
hire. That was used for transportation of ganja, whether he is involved or not.
That is a charge. No, in fact, this is going to be used for illegal. That is a charge.
Then why he was not made as accused? His vehicle is seized.
Because in the FIR is not shown.
Subsequently, the charge sheet may be.
Yes, yes, 16.
No, what is your occupation? What are you?
The third allegation is not, he has not made any representation to the, made to charge of single cases, 10 cases involved in the please. Then, not the proceeding.
You must be aware of the case. I mean, in the charge memo itself, you must have mentioned.
Mentioned regarding charge in the last 23, basically.
Line number 378 of 2019 under section 20B2. NDPCSI. Because of the criminal case only, you have initiated criminal proceedings.
That may be so, but your charge is not with reference to the transportation by the petition. Only allegation depends on the victim.
And it seems in the charge sheet, he's now,
No.
is accused.
So the charge.
Where is the charge sheet?
That is the article. Cause misconduct and irresponsible attitude for providing is one of the vehicle. Hence the accused, Eva. For transporting narcotics.
What is the date of this charge memo?
Charge is 2022.
4/1/2022.
Date of now.
What is the charge sheet date? This is date of charge. This is of 2019.
19.
Charge sheet is of 2019. And where are you shown as accused?
Where last yes, 24.
No, in the charge sheet you said you are shown as accused.
Charge sheet.
Page number?
Where charge yes, 24.
No, in the charge sheet you said you are shown as charge. Where are you shown as accused? What's your name? Munavat Subhakar. You are not shown as
Yes, you are.
A9.
Yes.
Yes.
Yeah, but my office is not, it is not related to criminal case as such.
But you
But
heard.
apart that, what can you see the circumstance? Helping other persons to transport the transportation is different case. Helping other person transport is only to the extent of whether he has provided.
Here also is shown as business
No,
only.
here we learned.
APRC, ARTC 389.
Apart from that,
That is wrongly shown.
sorry to kindly see the affidavit pleading does not stated what is the stage of inquiry, whether he has taken any objection to proceeding this inquiry. Nothing is clear. But he has given you reply to charge sheet or that no department judgment. Nothing is stated. He is seeking writ of mandamus. Unless he makes a representation or request not to proceed, he cannot come to the court directly and do 26.
But once charge memo has been issued, you know.
You have to give your explanation, no? It gives.
But take an objection first to the authority.
I am aware of my orders. Now, when he has raised such objection, you are supposed to answer also. So did you submit any explanation? In those cases, they have already submitted pending trial, inquiry, I have stayed.
Yes, ma'am.
But here also, have you submitted an explanation? Then, in those cases, inquiry officer has been appointed. An inquiry was supposed to proceed, therefore I have stayed.
They do the objection there. Postpone the inquiry.
So that in your case, circumstances you have to show. What is the stage now?
How not the officer is planning to attend the
Inquiry officer has been appointed.
yes,
Where is that proceeding?
full time.
Get it.
There
You
must
first amend your cross title and get instructions and proper
be
files.
file better affidavit. The affidavit also is not seen.
Next week. No, not like that. You please file a better affidavit along with the cross title. That will be better.
Item number 10, Nathan Reddy, Chief of General Administration, Chief of Home.
Allotment and wrongly because of a voting mistake. The allotment order is at page 14. And a constable working in appointed in SOL Nangareti cadre. Page 14 is the order. Based from the bottom arrow, the fourth line of first by local cadre, Nangareti. Allotted new cadre, Rajasthan Commission. Whereas my reference for my allots is at page 45. My preference matter. Page 45 serial number 7. Preference first Hyderabad, second Vikarabad, third Rajakonda, fourth Hyderabad. But they allot me to Rajakonda Mellots because they have noted my preference wrongly. That is also there. That's annexure P7 starts at 1, page 46. Understand? 447 Mellots is my serial number. Third from the bottom is the PT.
Petitioner's name is?
I'm sorry, ma'am. 2440. First case 3. Serial number Mellots.
Option 1 they have noted as Rajkunda.
Option 2 they have noted as Hyderabad. Option 3 as Vikarabad. Because of this noting mistake, I was wrongly allotted.
So have you made any representation?
Yes, my lord. The representation was annexure P8 is to the principal secretary, my lord. And annexure P9 is to the DGT director.
Yes. Dispose of the representation.
Make an appeal.
Appeal is
This appeal is preferred in
Appeal only, submission of appeal against allocation of new notice.
made in July 20.
Ah, so
But the allocation was made in December 20. Made an appeal immediate, but anyway, just
this question, the petitioner is challenging the only. So respondents 1 and 2, 2 and 3. Fine. The question is appointed disposed.
Item number 11, commission checking for general administration.
Because it is JEE exam written, the variation in preliminary and final, where 10 questions after shown already.
PSPSC. Who is appearing for PSPSC? Yes, notice before admission. Notice before admission. GP4, who is
Item number 12, chief for medical and health.
Now you have filed a copy. Where is that?
Petition is filed at page 102.
102. What is this representation? Acha, the copy you have taken a xerox. You have not given any details about your hall ticket number, nothing. How are they supposed to verify on this representation?
Yeah, 1 mask.
No, but how will they verify? How many marks you have to give your hall ticket number and other details. Hmm?
I'm the implementation actually the other after doing the dicta of every question. That we have case 20. 20 statement that I have brought 71 marks.
When we start in partial per give a basic presentation, partial IDC 103. The side will be fetching the ready. I don't find the petitioner's name will be cross-checking.
Surrender is not there. No. Literature itself is filed by Petty Surrender Reddy. Karuna Prasad file nemo, Karuna Prasad and 3 others and Rasal. Lopala petition nemo filed by one Mr. Petty Surrender Reddy. What is this? Our registry also has asked it. Registry is directed to return the file as there are inconsistencies in the document, the cost title mentioned by the commissioner and the documents filed along with it. Let it be.
Item number 13, Ramakrishna, GP for services.
Promotional. This is what can. That is direction. To be talking. It is not only not. It is referred to 14/2023.
Yesterday, actually, the representation was done Krishna field worker. Being the competent authority in the post of field assistant. So this is the representation you have made in July. This one has been forwarded to the authorities. So you want action to be taken and
the
yes, are you aware that have you seen this? But here the application is dated 26/2023, whereas here your representation is dated July 23. 31st July 23.
Here also going to that's fine. At least 16 now. 16 now.
This is dated 16/11/2022.
The pen is being implanted.
Yes. File it along with a memo or something. What is this? Then you can take time and do it tomorrow. But what is this attitude of, they are filing something, some documents, and you also give it across the bench like this? No, this matter was adjourned only for this reason, isn't it? So you are aware that this document has to come on record. Then you can file it along with the memo. Tomorrow, adjourn it tomorrow. Let it be filed along with.
Which are motions?
Then motion away tomorrow. On the day of. The urgent motion is there. You can't have everything, sir. He is now given concession. He said, I'll get instructions on that. So day after tomorrow in the urgent motion list.
Number 14, Ramesh, GP for services.
Yes.
The petitioner was initially appointed as junior assistant, 18 to 2017.
You are challenging the seniority list.
Seniority list of Millard, in fact, the seniority list was already finalized in year 2019. By following the seniority list, promotions are effected to the post of senior assistant. Now, Millard, after the new presidential order, Millard, the senior assistant post will not become a zonal post. By virtue of that, Millard, the district collector, Millard, zone 4, start for Millard, it's persons working in patrols of the junior assistant working in various districts to prepare the integrated senior list of junior assistants. In this district, Millard already say junior assistant cadre list was already finalized. By following that, Millard, list promotions are effected. Now, Millard, this sent Millard proposals, Millard, altering the seniority without Millard giving notice and after the petitioner.
Notice for admission.
Only my respectful submission.
Any seventh respondent is there.
I find Millard the appeal to the commissioner. Let them take decision. In fact, Millard, without disposing my representation, they are finalized.
You find an appeal against
Yes,
the changes. Where is that?
Page 46, Millard. Because Millard, they are going to effect promotion by following that seniority list. That is why Millard, I am immediately approaching the honorable court, Millard. Millard, I file appeal Millard, page 46, Millard. 40, Millard. The commissioner, Millard, who is the operator authority. Page 48. Millard, in fact, as per rules also, Millard, if an individual is accused by seniority, she has to appeal, submit an appeal within 3 months. In this case, Millard, 2019 seniority is finalized, showing me above the unofficial respondent. Now, Millard, without giving any notice, they are Millard altered my seniority. Page 48.
Yes, when the appearance is respondent. What instructions? Bill is dated 25/9. Earlier also you have submitted some representation.
But the commissioner is the competent appellate that in fact, Millard, I submitted various representations.
All right, I'll direct him.
So you have to let them by giving some Millard reasonable time. Millard.
Yes, preparation application is, though is challenged.
And number 15, Acharya, GP for services.
Yes. There is a rival claimant now.
Instructions, they directed me to get a succession. I have obtained succession. That is a case number.
But you're yourself saying that another lady who is also claiming to be the wife.
That's what.
That's why. But we have not made them as parties here in this.
I'm not saying that because already succession they have granted in the cure. Page 14 you have to make.
But then before the office, there is another person. In the succession, have you made them parties?
I have made them parties and office is also party to that. Page 14 you have to make that is the succession. One and two are the claimants, rival claimants. Office is the third respondent. Clerkship and kindly is the question. That is the page number.
This order is dated 9th November 2016. And now in 2023, you are coming to the court.
In 2027, 2027, they have issued a memo to submit knowledge to bring us to the compassion of. But till now, they are not paying the.
Without making them parties, sorry, at this late stage, you come without even making any of them parties here. What happened in between, who knows? 2016 is the date of the order.
2016.
Now we are in 2023, 7 years, long years. And you have not made them parties. No, I'm not going to entertain without making them as parties.
They'll file a petition to, but one more submission is, they have filed a suit taking benefits. That was dismissed. Appeal, referred appeal.
So that means there is a rival claimant. They are not, it's not just a final. Without making them, no.
So my submission to last, I can let them, no problem, because only thing is, once after civil court has declared me as the success, legal successor, and their claim was 50% of the benefits have been dismissed. So that has become final. Succession, judgment is, succession is a judgment in
We'll see that after we hear both of you. Not like this. She claims to be the first wife, you claim to be the second wife. Who is the first, who is the second, who is entitled? All that. Please make them parties and come, sir. When do you want? Next week.
Item number 16, Subbarav, DP for services.
You want the regularization of service from 16/10/97 to 21/10. Yes, for your pension. Yes, who is appearing for the petitioner? Who are the respondents? Don't have the bundle. We were not served with the papers. Huh? Tomorrow. You have retired from service. Have you made any representation? Where is that representation? 32.
Yes.
The representation is dated 16/6. So they have rejected it.
Yes.
And I told it for admission. This after 4 weeks performed.
Item number 17, Krishna, DP for services.
Where is that order? Yes.
Maybe posted at the police.
I'll post it along with that. I can pass order saying they want to continue as VRS. Let them continue.
This order will apply the interim director.
Pass and responsible will apply to the petitioners in these cases as well. So same similar. Similar order has been page number 51 and post along with WP number 28840. Yes.
Item number 18, HIGHCOURT, DP for principal administration.
The petitioner will get the suspension order and if I am not the criminal case.
What is the date of the?
Yes.
What is the date of the FIR? 3/5/2023.
17 minutes.
What are the charges against you?
The charge is one other person is fabricated one memo giving some benefit to the others. In addition, it was made a second respondent, second accused person. And charge memo is
Taking bribe amount without section, they name duly taking bribe.
fabricated memo.
Irregular payment of arrears and so on.
Page 26 is the charge mirror. And my inquiry officer is appointed on 29, page number mirror. They are called upon mirror 12/10/2023. It was attended on that day and submitted his explanation. Now, next date of hearing is mirror in this month. Short is there at page number 36.
Yes, who is appearing? Similar order as in page number 36. It's after 4 weeks.
Item number 19, Ravikiran, GP for services.
By way of an order, like the order was challenged by when appeal was filed. The appeal was not being disposed by us, the execution was filed before the Honorable Court. And the Honorable Court filed the directive because of the appeal. My appeal was rejected. And the effect was the appeal is not challenged. He has made a representation. Considering her plight, he has 3 children, and all of them are very well.
Appeal is rejected. Have you challenged that rejection or you're not challenging?
Yeah, only find the representation first. Consider her representation with this.
No, appeal was for to which place?
Challenging the aspect of changing her career.
From which place to which place?
Karimnagar to Bhopal.
Bhopalpalli. Now, in your representation, what are you asking?
When the
Transfer to Mahadevpur or Bhopalpalli? Both of them are in the same district?
requesting her to allot to either of the districts. To Karimnagar, Peddapalli or Jagishan.
Where is, in your representation, which is at page 12, this is the representation? You are asking only for Mahadevpur or Bhopalpalli. Whereas in your prayer, you are saying Peddapalli, Karimnagar, Jagityan. Which is the correct one?
This is the type of
Which one?
seeking transfer to Karimnagar. This is one of the representations what Mr. Urban. And apart from this, another representation was also.
Where is that representation?
But even then, never here, the prayer is to change her to Karimnagar.
You have been allotted to Karimnagar only.
Yes, never. Original carrier is Karimnagar. Yes, Asian country.
From Mahadevpur, Bhopalpalli to Karimnagar district. This will be change of local cadre, not just transfer. And appeal has already been dismissed. You have to challenge that.
That will increase more than 10 months.
Hmm?
More than 10 months back, appeal has.
You have to challenge this. Without challenging it, it will become fighting. What is the point again to be? Huh?
Challenging there.
I'll post it after Ravi to amend your prayer or do whatever. Whatever you think fit. Next week. And the request from the letter closed. Yes, next.
You mentioned as presentation date 4/9/2023.
That is not there. The places he mentions are not there in the representation. When you have noticed that your clerk has done some mistake, you expect the court also to do the same mistake? Is it not on your duty on your part to bring it to the notice? Yes, that would be better. I'll impose cost if you people do like this from next time.
Item number 20, GP for services.
They're asking for promotion. They're challenging the promotion of the unofficial respondent. All right, notice of recognition. And then the GP for services 1 takes notice on behalf of response 1 and 2. And then also for admissions permission to take for personal notice on number 3. This after 4 weeks.
Item number 21, Lakshmi Narasimha, Chief Minister, Shri Praveen Kumar.
They're asking for regularization of services. The care of junior lecturers vocational on par with similarly placed persons. Notice.
Correct, the lots of issues. Commissioner of Intermediate Education, can you look at it?
Page 19. 90. Yes.
Detailed report is something in comment. Page 115. 1720.
26, 6, 23.
Page 115.
Reference to something. Yes.
You are speaking that I just couple of play. For our vocational junior lecturer to publish it for regularize against double sanctions death merit for sanctions death of the 650 post of junior lecturer. It's some vocational speaking.
Mm.
You permission for regularize against double sanctions can be right now we want to regularly working with them. MTS is MTS not in any class. There 0.16 does not talk of MTS and take the minimum time scale.
No. They are MTS is multitasking, I think.
Well, here it's called minimum time.
Time scale. Okay.
Third one is contract regulars. Yes, contract regulars. 184. Abhi regular. Also, we try to see 116. There's a table is there.
Yes.
Eligible but not regularized as 175. Keep far under this. And other regularized next to a lot of 180. There are still 175 candidates not registered. So if we are directly government to take a call, he has given a detailed report on it. The contention is that all of us are fully qualified and released. But I said statement that 060.
This is the information submitted to the secretary to government. Why was this information called for?
They had some doubts as to who was qualified, who was not qualified. How I take the law. At page 87, this is the amendment to an act. And the relevant page is at page 88. In the Andhra Pradesh Public Employment Registration, after section 10, the following new section can be added, namely regularization of services of persons appointed on contract.
Yes.
Notwithstanding being contained in this act, the government of the person appointed on contract basis. You will also put the MTS is not there. There is no such concept of MTS. Goes in the government subject to fulfill conditions. There are 6 conditions here. This data was submitted by the government. As an interim measure, will also find a translate targeting the government.
Have you made any representation?
We do not know whether we are there or not. And it's very clear.
So let's get instructions then. You are appearing for whom?
The other aspect which I want to detail also the government of India, you will also make this they have given a notification under the page 65 after the bifurcation in the world.
No, how is this government of India?
They have given how many posts are vacant and how many paid 84 years. AP paid 84. AP fairness and super districts, zonal and multi-zone. What is the zonal? At that point of time, zone 5 and zone 6. Now you are also to see at page 85. The relevant page would be at page 86. Intermediate education, all belongs to intermediate education. Down below that you are also senior lecturer vocational courses. TSHC, okay. Sanctioned posts are 842, vacant posts are 801. So this is where the government in India comes. When 812 posts are vacant, so 842 posts are sanctioned. That can't be reduced because it's given by at the
So
time.
let them get instructions. Like of the instructions.
Only one request for it.
Notice me for admission to staff of 4 weeks for form.
So what's my direct government take a call?
Let them come.
It's only participation for the
So that he'll get instructions as to what the government.
listen box. Like instructions were very difficult to get. I think it's not record pass the model. We come back again.
Notable for admission, the learned GP is directed to get instructions as to the out. Sir, if you want this admission to be disposed of at the admission stage, please do it. It's not, can't be disposed of at the admission stage. Then without instructions, no.
Before the things you also the directing can pass the point. So that I would be.
If there is a representation, yes. There is no representation, so it can't.
65% very difficult to get the representation.
All right, so let him get instructions after 4 weeks.
Item number 22, Anirudh, GP for services.
My lord, for the petitioners, my lord, the same case we have given a representation, my lord, dated since 2022 October 2, 2023 September, we are giving continuous representation, my lord. Kindly direct the as per appropriate law, kindly dispose the petition, my lord. The same case which we discussed right now, the nearly 90 members are there. We have given representation with acknowledgement, my lord. Kindly direct response.
Yes.
As per appropriately, madam, we are not asking, not against the law.
Where is your representation?
Madam, my lord, page number 41 to 54, my lord.
This is the association making their.
No, not association, my lord.
Then-
Individual members has signed, my lord. Each and every kindly. Page number 44, my lord. 46, all are signed, my lord.
The letterhead is given by the contract vocational junior lecturers.
Yes, page number 46, my lord.
Without giving any details of what they have done, nothing.
My
How
lord,
can it
page
be?
number 46, my lord.
46.
So all are
What
signed.
are the details you have given?
My lord, we have.
You have only given your phone number and for where you have worked.
44, 45 total information, my lord.
What-
44, 45 total in subject.
What information?
Letter, all GOs are mentioned, my lord. Whatever we discussed right now, in item number 21, all the, it was there, my lord. 44, page number 44.
You have
page number
mentioned
49.
the number of posts which have been sanctioned and other things.
Yes, my lord.
Now, who are these people who have signed 175 signatures? Who are all these people? Where did they work? Which subject? Nothing is given and you want them to dispose of.
My lord, one second.
Same writ post along with 4 weeks.
Item number 20,
Per counter on.
item number 23, EVS action, GP for higher education.
Yes.
I'm checking on behalf of Mrs. ABS Lakshmi.
Yes.
Now, the petitioner on 19/1/92 joined as a lecturer and later became an associate professor by proceedings dated 25th July with effect on 13th January 2021. And he was further promoted on 13/10/2009 and the proceedings of 11/1/2010.
You want promotion as
Yes.
senior professor?
53 professors have been given promotion without inclusion of my name or candidature.
What is the reason?
In spite of this, they have not said anything. I have made representations.
Where are the representations?
Representations, page there are 7 of the affidavit and page number 9 of the affidavit.
Copy of the representation.
Dated 12/11/2000. This is the representation.
Then
I apologize for your time. I've given the facts, but the copies is there.
next week.
Apologies, madam. Yes.
Today, everybody seems to be in a very this mood of not filing any documents. You expect the court to give you.
There are humbly submit that to the your apologies are submitted. I was thinking the legal having running to the court.
Well, filing the repression, you are not in a hurry. Is it?
I am not.
The file is in the file, the representations are missing.
Once again, I apologize.
Today, everybody seems to be in that. You know, and now I think 4 or 5
But I'm
representations all at the time.
about my apologies.
Yes.
Okay.
Item number 24, Ganesh, Chief of Panchayat and Rural Development, Chief of Finance and Planning.
Yes, Mr. Ganesh. Don't want to amend your. What is this? You have to file it in the court, no?
No, madam. Again, that's value the section, there's no extended section.
You have sent it to section.
Yes,
Okay,
madam.
all right. We have to send it to section, get everything amended and then come. Next week. Is this how it is worked? Is it how, last 2 years I haven't seen this attitude. Is this how you file the papers, amendment petitions just across the bench?
No.
Then what is this?
Friday, the most we must find out today, my.
Then you should have asked some more time then. Or you should have asked time now. Instead you are handing it over to me like this.
No, I filed it.
All right, I have posted after 1 week. Before do everything in the registry properly and then let it come.
Problem.
Item number 25, Srinivas, Chief of Services.
There is a copy of the representation.
Page number 15 is a payment of gratuity after serving 33 years when retired from service. Instead appointed in the 1982 and retired from service to the page number 15 is the representation.
15 or 50? 26/9/23.
26/9/2020. Page of acknowledgement. The similar case last time.
Yes, where is that order?
Now we should look at everything number 3043/23, but the dates are different, madam. Appointment dates and retirement dates are different.
So you want this representation to be disposed of?
Yes.
Yes? This request, the petitioner is seeking a direction to the respondents to release, grant of the release. Gratuity to, and is seeking a direction to the respondents to consider and pass this pass orders in the same. The learned GP supervises to, and for the respondents. 1, 2, 3, and Mr. Kishore Rao. And then standing counsel for respondent number 4 are also having got to the fact that the representation of the petition is pending with the respondents. Respondents are directed to consider the same and appropriate order thereof within a period of 6 weeks from the date of this document.
The date of appointment, date of retirement.
Only date of retirement I have mentioned in the other sheet. In the retirement, May 2020. May 2020.
That's the date of the schedule. With humble submission and apologies, the representation is already filed to me, Lord. Due to oversight, I have not come across that. I abide by this court order of next week posting. but the representation is attached, personal as well as the association.
All right, so you can withdraw your appointment.
No, madam. Once again, I am re-apologizing, madam, for the error
All
or
right.
whatever is due to oversight. Madam.
All right. Okay. Yes.
And number 27, in the law, Dr. Praveen Kumar.
I got the instructions paper. You have to communicate to pass.
Yes. What was the issue? Certificates. Why you are not giving the certificates? Yes.
There are three committed to this.
Mm.
During the document verification conducted for the candidates who qualified in the written examination and TET, it came to notice that the national apprenticeship certificate submitted by the number of the candidates showing the month of the passing of All India Trade Test as April 2019, while the NCVT examination was conducted during the period of 25/2019 to 14/6/2019. There is a, contradiction between the
Yes.
both reports, so that has to be this query has to be cleared by the railway equipment. And respondent number 4 has forwarded the letter to the railway equipment board. It takes time, and this is not pertaining to only 3 candidates. Totally 386 candidates are there. So it has
So as per the, it is an anonymous situation. Mentioned that the candidate should have appeared in the NCTV examination on or before 12/4/2019.
yes,
Whereas this examination was held for this candidate on 26.
25/2019 to 14/6/2019 was the examination date, and then the results were declared in April 19 only. We require some clarity. For this clarification, we have sought the.
My opinion. My intention is only that the skill development is not giving certificates.
This is with regard to December 2018.
My lord, these instructions are given by railways. Railways is a party, but skill development gives the certificates. Railway will give the job. That is a
No, who has to give you the certificate, skill development?
skill development giving certificate.
That is respond number 1.
As per the
You have got instructions from the railways.
TN4. This is TN4. Instruction from TN4. It is not valid.
We have forwarded our clarification.
No, I have noted down when I recorded here. This is with regard to examination conducted in
December 2018.
December 2018 and May 2018.
This is what is not
No, examinations were conducted in May 2018
yes,
and December 2018 certificates were supposed to be given. Why you are not giving it to him? Them? That's all. You are talking about examination held in 2019.
Yes, railways. That is
Yeah,
railways.
other candidates saying he is not giving some clarification.
Before even they can participate in the railway examination, they need their skill test certificate. So that has to be given by the first respondent.
If we are we will get the clarification. Hopefully we may be granted.
For what? You have to just call them up and find out why
We
they're
have
not.
forwarded, we will get the instructions.
I'll give you 1 week's time. That's it.
2 weeks.
Otherwise, I'll ask that person to be here. Who has to be here? Director General of Training. Let him be here.
2 weeks time we will granted, we will get it.
Only 2 weeks. If he's not sending you this one, he will be present. Yes.
My lord, kindly direct the response to reserve of these personnel.
Not only three, you are totally 386 candidates are there. Not only 3.
Already I have qualified during December 2018 in all subjects. I am supposed to be given job. And moreover, my posting orders are on hold. Kindly direct the response to reserve 3 for 3 vacancies.
And get the instructions.
These instructions are from railways, but railways are not.
I will get the instructions to the responding one. So this time will be granted.
No, according to these instructions, when are you going to finalize those posts?
So this time we
No, no, when are you going to finalize those posts? According to these instructions.
that has to be clarified with the railway board, may not respond at this time. This time. But I get the instructions. All the respondents. This time.
As they are trained, so. Yes. The learned
My lord.
candidate 20th, it's on 20th,
My last CC
2011. CC.
Item number 28, Manav Kumar, Category Kumar.
You are appearing for?
My last. But then my last. Regarding the developmental strategy of this actually the lower court has charged the direction because the petitioner may not in the letter in paragraph number 4. The lordship states
So civil court has attached the,
Supreme Court has attached, they have reached to CAT and CAT gives a direction, my lordship, that gratitude cannot be held. Gratitude, I mean like the
cannot be held. Attached.
attached. So the civil court, CAT gives a direction to the Union of India, prefer ES in TEP. So we have already completed the articles of the CAT. And if they have the rate is not maintained over the lordship because lordship may
All right, he is not Mr. Manav Kumar, no? He wants a passover. So passover, you want next week, 1 week, on that next week.
Number 29, Aarti Chakravarti.
Maruti,
With your kind permissions, my lords,
Yes.
I'm appearing for the petitioner. The petitioner is a bank clerk, my lords, is challenging the writ petition. This writ petition again is the inaction of the respondent numbers 2 and 3 for non-considering his representation. He
have
is a clerk of Indian Bank, my lords, respondent number 2 and 3. While he was coming back to his home from his office bank, he met with an accident, became infirmity of mind. The CT scan is kindly, your lordship may see the CT scan page. My lords, page number 21 to 24.
You have certain medical conditions according to which you cannot go and work.
There is
you
a,
working now?
my lords, there is a banking clerk policies there. When
Where are you working now? Where do you want to go?
Kana Shantivan, I'm working with respondent number 4, my lords.
You are working in Kana Shantivanam.
Yeah, branch.
Want to be
Indian Bank.
transferred to?
Transfer to Himayatnagar currency chest because he can't sit. Doctor advised him not to sit long hours in front of the system, my lords. That is the reason he requested respondent number 2 and 3 to transfer to do manual work in Himayatnagar branch currency chest.
Where is your representation?
Yeah, kindly you may see page number 13 to 14 and 15 to 16, my lords.
8-7 and 13-7, 15-7. Yes, who is up? Union Bank, anybody? Indian Bank. On that notice, urgent notice, to take out urgent notice. Okay.
Much obliged.
The petition is permitted to take out urgent notice, personal notice, response 2 to 4. And this after 2 weeks.
Much obliged, my lords.
Number 30, Kavita. The issue pertaining to the patient you could also, I think the last we replied. Then the senior this was also drawn. We have figured some, considering the junior, in cases of the petitions of non-considering, and the grounds that where the against the recruitment agency, a criminal case FIR is registered, also against the number 57. The Union Corporation of India, for the purpose of recruitment, whether we have endeavored to the work to the one of the agency. Either our names are triggered or the Union FIR is concerned against the agency.
So you want to be considered for promotion?
Promotion, when there is a judgment of determination of some court, Seven. Under the Department of Police for commences from the issuing the charge memo. Whereas the criminal cases are concerned, the commences from the charge sheet. In the even assuming without admitting, when the FIR is taken consideration against this, there cannot be a ground to delay the promotion. That is the only solve the issue.
And the request of the 11th Standing Council for the responding. Written motion.
Okay. Number 31, Venkatramati, Chief of Forest.
Dismissed from service.
11-48. This whole ground judgment is convicted in exceptional case. This is exactly. Page 20 is 51.
Now the criminal case has been,
It is external, that is external case. Appeal.
so after that, have you made any representation?
Cases.
Where is that?
It is a page. 69 and 72, 78. 22, 78.
Hmm. Thirty-eight, 23. The latest is 38. When were you acquitted? When were you acquitted?
2/8/20, August 2020. This page, because
Immediately you made one on 19 and then later on,
later,
38.
38/2022.
you want these representations to be considered.
Yeah, and then, 81.
After that, they only will have to consider your case for reinstatement. Now let them consider, let them take into consideration past orders. Then you may,
Again, but the
I don't think they will have to, they,
Windows service that from 2008 to date there on this whole road.
so let them consent past orders, then we can come in. Need be. Yes.
I am getting this.
In this situation, the petitioner seeking a direction to the respondents.
Item number 32, correct, Chief of General Administration, Chief of Finance and Planning.
Yes. Not regularizing the service of the petitioner. Even after the annual grade increments. They cannot serious, growing continuous serious, simple carry. Without ordering his reversion to the fetal category. What is his place? Yes, notice. Who is appearing for the response? Hmm? What about the others? You are appearing for? R3. You are appearing for? What about 1 and 4? What is the for admission? GPF services.
Number 35, Raman, Chief Secretary. Great.
Counter is not filed yet.
No point.
Notice is not ordered.
Stage of admissions in matter was never argued. Once I argued through virtual mode and I was asked to appear before the summary court and again appeared and other side took pass over and it got adjourned again. Again I came to here. And
So notice was not issued.
Really understanding of this case without opening the bundle no facts are relevant. All the petitioners are landlords. They lost lands for construction of power generation station, that is KTPP, thermal power station, Karpira thermal power project, KTPP. Now, at the time of acquiring their lands, they were issued to provide employment to one member in each family. And GOMS number 98 is there, which says that Milad, a post should be equivalent to that of junior assistant cadre, and whenever regular recruitment notification is given, 50% of total number of vacancies would be earmarked for the landowners. Now the whole grievance is given of the petitioners is that in the year 2006, they lost lands for construction of KTPP. Till date, they were not provided regular employment, that is the whole grievance. Now, this is second round of litigation. Earlier, they made a presentation, approached the Assembly Court, and there was a direction by the Assembly Court to consider the representation. It was acted upon, a speaking order was passed, against which present petition is filed. Still more, Milad. A interesting fact is that Milad, in power utilities across the state of Telangana, about 24,000 employees were working on outsourcing basis, who got entered into the service through backdoor. Though we have no grievance against them in personal capacity, this fact is very much relevant. Reason is that Milad, they all their services in power utilities with that about 5,828 number of outsourcing personnel. Their services got regularized. 5,828. But Hero says whenever recruitment notification is given, 50%. Now they fill up all the vacancies by absorbing the services of outsourcing personnel who got entered into the service through backdoor method without following rule of reservation, without there being any recruitment process, without there being any recruitment notification, nothing like that. Now, the whole grievance of the petitioners now is that you treat that whole process of absorption of either 24,000 or 5,828 personnel as a recruitment notification. And it means equal number of posts supposed to be earmarked for the sake of land users. That process was not adopted. Because of that reason, we had these people are not getting employment. Question of issuing recruitment notification in near future would not arise. Because of the reason, all the vacancies got absorbed.
Yes.
All the vacancies got filled up with the workers who were working on outsourcing basis by absorbing their service.
Notice. Who is appearing for response? Denko. P.S. Denko. Who appears? Denko. Umadevi, no, no,
Yes, Umadevi, madam.
Umadevi takes notice on behalf of the respondents. And list after the previous. What interim order can be given in this?
Great respect, Milad. Division bench of Islamic Court. There was an occasion to deal with this kind of matter, same prayer. I made permit to take a last kind of attention to that portion alone, and I accepted the same. I filed the same as one of the middle paras, as well as I extracted that portion in affidavit even at page number 19, para 23.
Yes.
That is WP number para 23, page 19, WP 3279 of 2017, and the division bench order it was passed on.
So now there is a direction.
2019.
There is a direction to the state government to have a comprehensive look into the entire issue and place its detailed response after putting to and considering. So what have they done? They haven't done anything.
No, they have done. In fact, Milad, unfortunately, that matter got closed. But I'm only relying upon the spirit of the SADA. What was the intention? They have taken away the lands of the poor people. They lost their livelihood. There was a promise to provide them employment, and you have been providing employment to various other people, but you ignored the candidates of the landowners to work out some remedy to the landowners by taking a comprehensive policy.
All right.
That was the sum and substance of the order passed.
It's after 3 years.
And our damage is
Without hearing them, it can't be. No order to be passed.
Obliged, Milad, and my submission is that you have to open this, say, the motion is good. Otherwise, Milad.
Urgent motion. Yes.
and number 36, Venkatram, Chief of Medical Health.
All to go with the batch.
And number 37, Tilmal Rao.
Okay.
He retired on 31/1/2021. And the charge sheet was given to him. The charge sheet was related to he had given a FIR regarding some loss of materials. And he had not given proper particulars. And not only the charge sheet was inquiry, he also kindly see the order of the disciplinary authority, which is also related to page 17. He imposes two punishments, which is agreed. In the sense, it is not provided in the contract which page 13 rules. That is number one. And thereby, when also page 79, they say that he cannot be declared as a member of the pension scheme. Now, not to be a member of the pension scheme, there are two issues. It can be either compulsory tax or dismissed or removed from service. That you also should get it as per the definition of member.
So this is against this punishment order that you have filed.
Yes, yes, based on.
All right, notice. Who is appearing?
It's not plain. It's not. Actually, the pension scheme provides to remove remove 1/3 of the pension. That you also will get it. And there is the interest I made because it's the pension scheme. He cannot be deferred with the pension. Leave alone it, the pension scheme itself does not provide for
See.
pension.
Unless until you are a member of the pension fund,
Yes, sir.
how will you get the pension?
No, no. The disciplinary authority passes an order that I cannot be declared as a member. That order is bad in law because not to be a member, three conditions have to be satisfied. He should have been compulsory removed, retired, dismissed, or removed from service. That I am taking your lordship beyond the rules. That's what I'm trying to say. Okay, so the definition of member. That is also the kindly get it. Page 36. I'll file the scheme. What contingencies it says? Member can leave an employee. Be
shall be an employee in the executive cadre who has been submitted as a member in the scheme in accordance with the provisions of the scheme, but shall not include an executive who, having been admitted as a member and subsequently ceased to be eligible to a member as herein prescribed, or ceased to be employed in the company by virtue of removal from service, dismissed, or compulsory retirement. Neither of these three things are there in the order of discussion. It was neither compulsory retired nor removed behind a normal retirement. Only thing is the charge sheet, the charges of fraud subsequent to that. So these three conditions are not finding place. So thereby, they cannot be deprived. He's already a member. Now they are saying he cannot be a member. So thereby, what I'm trying to claim under the scheme, under the state of option. Page 41, member contribution. The last paragraph. Notwithstanding any contract, the company shall not be entitled to deduct the employee's contribution from the salary of the member or otherwise to recover it from you.
Page number?
Page number 41. Page 41. And the member contribution clause member.
Yes.
Last paragraph. Notwithstanding any contract, the company shall not be entitled to deduct the employee's contribution from the salary of the member or otherwise to recover it from you. They are not entitled. The company is not entitled.
Yes.
And again,
this is in the new pension scheme.
Yes, these are new, it is told by security bonds, and he is entitled to take withdraw non-fair, that also taken.
Of members' contribution without giving any reason.
Yes, sir. So, exactly is funded by security bonds. This is a traditional pension scheme. Really, they are getting the government pension scheme, they are getting, that is very big amount. So, what the company has done subsequent to the wage revision in 2017, they have introduced a separate pension scheme. Whereas there are several riders. So more interesting or not is the clause 5.1 at 347 processual candidate. 5.1. The fund shall be constituted under the trust established in India. It shall be an irrevocable trust stayed with the consent of the beneficiaries of the province and income taxes. No money belonging to the fund. No money belonging to the fund in the hands of the trustees shall be recovered to the company under any pretext whatsoever, nor shall the company have any lien or charge or any discretion on the same, save as has been provided. They have no right. Still, they go ahead. That's more interesting in clause 8 minutes. Very interesting. The last thing is pausing the lot. At page 55, clause 8.2. Clause 8.2. No member beneficiary shall have any interest in the master policy taken from the process under the rules, nor any investment otherwise made with the accordance to terms. Next clause is clause B. No money belonging to the fund shall be distributed by the employer. Under circumstances, nor shall the employer have any lien or charge of the fund. Inside all these things, when I am neither compulsory retired, nor removed, nor dismissed, I am entitled to the fund. And in initial stage itself, I am entitled to take 1/3 of the amount. That's what my intent here is. To permit me to take 1/3. The rest of the amount may not be got as an annuity. In the annuity service provided LIC. What they do is we prefer a bank and the bank will start paying the annuity. The 1/3 I'm automatically entitled. There is no embargo on that. That is the interpreted amount.
1/3 of your contribution.
Yes, employer's contribution. Not everybody is employed. There is no contribution from my side. This employer contribution cannot be.
No, employer's contribution you cannot withdraw. It is only the employee's contribution. You are not contributed anything, then you can't withdraw.
No, it's like this one. Even though the employer has given the entire money, this money is totally beyond the hands of the company unless I have been dismissed or removed service.
Yes.
Page 45, it says that it is subject to any disciplinary procedure.
Yes.
Page 45.
Yes.
4.6.
Yes.
And that has been over. The simple things are now over, may not. The punishment order has been passed.
Now the punishment order is whether it is in a PDA rules or not.
I have also said that I have arranged the rules, may not. What punishment they can pass.
Only let him file counter letters. Yes.
But it's not.
Notice before admission is after 4 weeks.
It's not. Second motion. It is a sanction. Second motion.
It will come in the list now, daily list also will reach now. Yes.
Item number 40, Venkatraman.
Are we same with that? That's different. I thought the stage. Okay. You're challenging what?
Suspension order of liquidation because of engagement.
Your suspension or dismissal from service? Dismissal order.
Did not complete the. The reason behind that we got 96 page number 20.
There's no appeal?
Appeal has been filed.
All right, then notice of submission is after 4 weeks for count.
Please. Only one. 96 page.
Yes.
The second pair.
Hmm. See, no interim order can be passed in this. You have been removed, dismissed from service, appeal also dismissed. Let them file counter, they will come.
Item number
4 weeks.
He is not getting any money.
If he is dismissed from service, he will not get money, definitely. How will he get money? Yes.
Item numbers 41 to 50, special arrangement cases. Number 41, Uttam Sumaradi, Chief of Education.
No, interim order ఉంది కదా? Same. With liberty. Close with liberty to challenge. Yes.
Item number 42, Ram Gopal Rao.
They have done it. List after 2 weeks.
Item number 43, Ram Gopal Rao, Chief of School Education.
So, appeal for the petition has been allowed, no further orders are necessary. Closed.
Sudhakar Reddy and Neeraj Reddy. Item number 44. No.
Next week. 44, 45, 46, all three same.
45
Item 45, Sudhakar Reddy and Neeraj Reddy.
44 next week. 45 rejected, closed with liberty. So both. Yes. Both closed with liberty. To find it.
Item number 47, Ram Gopal Rao, Chief of Education.
Same. With liberty.
Item number 48, Sudhakar Reddy and Neeraj Reddy. No orders. No orders.
No, next week.
Item number 49, Ram Gopal Rao, Chief of School Education.
Next, same, with liberty, closed.
Item number 50, Ramu, Chief of School Education. No orders.
No orders. How it is, it's just. That's why it has become, no, the issue can't become infectious. Council may not be able to represent in this capacities of council. So 2 weeks, we start.
Item number 51, Srikant, GP for Services, Ramalakshmi, Ram Gopal Rao.
I've heard this matter, but no, I just want to know what is the government stand. Government has not filed a counter. This is, you argued the stay vacate, and I said I'll take it as heard for the repression itself. The government counter is not there because see the general rule, ad hoc rule you have shown. A special rule, each department has to pass an order. They have not passed the order. So what will be the effect? What is the stand of the government?
First, government is concerned, I drew your last attention to 282 GO.
Yes.
Which did not say that following this could be subject to amendment.
No, but then it also says that each department should again pass orders.
Yes.
And you are aware, special rule will always prevail over general rule.
That is why, madam, we will have to see 282 for 1 second. please.
No, let the government say what their stand is. I am granting 1 week's time you file your accounts in this matter. It's a long pending matter. 2022 matter. 2 weeks.
Yes, ma'am.
For the count of the respondents, it's after 2 weeks. The government is after 2 weeks. Once that is known, then we can.
May,
Only problem would be this matter. Supposing they don't do it at all. We have no application, cannot be the way of looking at it.
No, ad hoc has an application, if we take it that way also. When the special rules are there, special rules will always prevail.
Now, it's case, not with
minutes, my respectful submission is minute.
special service rules, or any other rule governing the direct recruitment, it is an all-encompassing one, including special law. Then finally, what they said was, this is not a part of the order. So, paragraph 5 says, the Department of Secretariat issue necessary amendments to service record accordingly. Till such time, this will be not operative, is not what this GO says. This is also mirrored, the Lakshya also are aware. All the orders are made, rules are made by President, government exercises the government provides to Article 309. This is also one made by. So the fact that these special rules were available is a knowledge which is presumed in the delegated legislature while he passed this rule. And that is precisely the reason why it says, notwithstanding anything contained in the special rules or any other rule. So it is all encompassing.
And then file conflict, if the government also. Yes, stop to.
My thing is, my lord, I only say that finally, if the tag is not there, my lord, we will be out of employment for continuation period. That's the only request. You're on the after 2 weeks, your lordship is saying they will have to get a or at least a written instruction, because technically they may not have a serious objection or whatever it is, but let it come by way of a written instructions. Also, your lordship.
That's why it's better to that they file a counter affidavit, so that it will be on record
Very
and it can.
instructions is what I am requesting your lordship to consider that.
Yes.
So that they may not ask it as a mechanical thing, saying that you have 1 more to buy. That's the only I am doing. Grateful to your lordship.
Item number 52, Krishna.
Directed to conclude the receipt proceedings. Submitted to HIGHCOURT. Pursuant. And in the court. Court. The word not was missing there. But being mentioned, Nisara, petition is surrendered. What is the date?
About 5 years.
You have filed today. It's not listed. Get that filed. In the IA, you have mentioned that only. Yes. And IA 2 is allowed. This is directed to issue amended copy of that.
Item number 53, Sudhir, People Services, Srinivasrao Maharaj.
Yes.
Lord, I'm appearing online, my lord.
Yes.
Lordships are able to hear me, my lord.
Yes, I'm able to hear you, but the GP wants time, Passover.
Passover is okay, my lord, but this is what is happening. Your lordship, can you see that the impugned GO was set aside by themselves only, by the government, because initially they tried their best to sustain, and then finally they said they have done it on 3110.
Yes, now what is the problem?
No, that's what, my lord. The 3110, when GO was, the impugned GO was drawn back or cancelled.
Withdrawn.
Earlier GO comes back, 275 comes back. When it comes back, my lord, automatically I have to go and join, and then he has to get relieved.
Yes.
Because he did not do so, and then very cleverly, in 386, my lord, he again wanted us to go to him for posting orders.
Okay.
But then I went also immediately, my lord, on 30, it was given, my lord, on 3110 to me in the court. First, First matter came up and second, he went and on my advice, he went and reported, despite the fact that he can directly go and join. Because the latest GO says that I should report before the principal secretary. I went and reported.
Okay,
That is on second.
okay.
Nothing, no orders are passed, till even now, the situation is status quo ante, whatever was happening.
All right, pass over.
Much obliged. Obliged.
Number 54, Allahabad Distributed Energy.
Yes. Suspension order. Who is appearing for the respondents? Standing counsel, who is the standing counsel? Huh? In the name of Ms. Umadevi and list on Wednesday. Umadevi as counsel for the respondents, list on Wednesday. Same list, adjourn motions. Yes.
Item number 55, Nursing Home, Chief Services, Ram Gopal Rao.
Yes, please.
Literally, he filed a writ petition in apprehension that he has not done it properly, the public, before the results were declared. There was direction to dispose of the representation. The batch was pending in respect of other candidates. Finally, recovery. For your mistake, you cannot be held responsible. Therefore, all the public cases have been dismissed. To that extent, we are okay. But here the plea taken in petition, I filed that. But when I obtained my lord, it was called for 1:3 certificate verification, this kind. After declaring result, because I don't know. We had at that point of time, it was called for verification. Those batch of writ petitions were pending here regarding public. But we subsequently obtained application in the RTA, the original OMR sheet, but we filed the influence in the So in the original OMR sheet, they published it properly. Now they are coming with after obtaining that OMR sheet, 21, 23, that they make a representation that can.
So what is their place now after the OMR sheet?
No, my stand with the same, you filed.
No, they are saying they are meritorious than the other candidates. What is it their prayer is?
They are silent on this aspect in the way.
There is no error in bubbling of the petition's answer script while appointing less meritorious candidates than him. So that means your paper has not been considered at all. What is your case? That your OMR sheet has not been considered at all. Yes.
There is no bubbling in the OMR sheet.
There is bubbling. No, there is no bubbling error. So they must have considered. So they must have considered your case, no?
Not considered. Only they consider certificate verification. In appointment or non-given. You are kindly. Certificate verification.
No, you will be called for certificate verification only if you qualify in the written examination.
Yes.
Then that means they have to take in your OMR sheet into consideration.
Consideration, my lord, only because the bubbling batch was pending, their cases have not been considered.
Why don't you?
Notification,
I already properly published in the OMR sheet.
30264.
Cases. Same issue.
So what are you saying in this? The subject social studies, there are 9 discussions for studying wrong on topic. The same report of school the result is pending.
Yes. No, we are only the RTA Act, recently, But this RTI Act information, they filed this petition, that they make a representation, not get a standard act. Not more than that.
Yes. WP number 30262 and next case code.
Number 179182 of 2018.
Yes.
Item number 57, interesting on deep massage.
Yes. You are challenging the punishment of reduction of lower rank.
Yes. The inspector officer will ask for the update the signatures of the and other submitted report. Basing on the report, the punishment is improved. Applied appeal, pending appeal, there is no implementation of the other punishment.
The large class text, the large form.
Directed them to
Inquiry
find.
report, inquiry report. And asked them whether the punishment is implemented or not. I have stated so in my appeal class. Pending appeal, there is no implementation. Of
Yes.
punishment.
Not been implemented. All right, file your counter then. Notice before admission. List after courses for count of the respondents. There shall be instant suspension of the impugned order dated 24/1/2022.
Item number 58, Ganesh, Chief of Panchayat and Rural Development, Chief of Revenue.
That is a termination order. They are not terminated.
Based on my FTI application, madam, they are stated, madam, there is no job for you, so you are not allowing me to the, not allowing the working as a car.
They say you have not responded to the notices. They say you have not responded to the notices sent by you, them for attending. Therefore, they have taken somebody else.
Yes, madam. More notice you have not responded. Very outdoors is
Next week, you'll file your form. At the request of the learned static council. The filing is out there. Just 2 weeks, just after 2 weeks.
Before that, madam, the unofficial based on the allegations, madam, inquiry of the CPO, madam, reinstated the issue notice, madam, stating that reinstate the petition, madam. Even that implement, that orders also they are not implemented.
Dispose of the representation, then in the meantime, tell him the reason why you are not taking it.
More notices, he has not responded for that. That's what he insists.
Where is the representation? Where is your representation? Page number? Yes.
Also, when found murder, the teams still
రోజున విజిట్ ఆఫ్ చెప్తాను వెళ్ళినాను కానీ పంచాయత్ కార్యదర్శి గారు మరి నన్ను విధిలోకి రానివ్వడం లేదు, నన్ను హాజరు రిజిస్టర్ లో సంతకం పెట్టనివ్వడం లేదు, కూడా రానివ్వడం లేదు. 6/4.
Even there is, he has not appointed even 2003. There is no appointment order.
If there is no appointment order, then why do you say that he is not coming to the office? Therefore, we have issued notices. Why should you issue notices to him if he is not appointed? In April 2022 itself is saying that you are not permitting me to come. This is on 25/8/2023. Is the letter issue, you are saying that, because in spite of several notices, he is not responding. This is in August 2023. Whereas his representations are in April 2022.
That is still not in this.
So in this letter also 47, how can it be backdated? Your stamps and your signatures are all there. How can they be backdated? Acknowledgements are there on this. Received by on 18/4/2022. And this letter also doesn't mention anything, any notice. What is the date of that notice to which he has not responded? When did you give the notice? Nothing is there.
Seeking the implement of the DPO order, ma'am.
Where is the DPO's order? This is in 2022. Whereas they say something in 2023. Next Monday. Same list.
Item number 59, Keshava, GP for Panchayat Road Development, GP for Revenue.
Petition is working as unsuccessful in waiting. He was absent for 2 months. 28, for the 2 months, immediately after 2 months, he submitted a joining letter. Then he was absent, he was given promotion order. Here, dispute is that from the date of issuing the joining letter, they did not take the petitioner into service. 2019, he submitted representations also. The district panchayat officer is not allowing the petitioner to join the duty. He is not relieving the petitioner from the service. In fact, the commissioner has already issued promotion orders, and the district collector had issued orders to relieve the petitioner from the service and given promotion orders. This is one aspect. In fact, the commissioner has also issued show cause notices to the DPO, Rangareddy district, why he is not taking any action. He says that the petitioner is not available. In fact, he submitted a representation. In fact, he filed an RTA application also, where it is clearly said that he is promoted to the post of Mandal Panchayat Officer. Now they are not taking the petition to service from the last case. The lordship directed
Yes.
instructions.
I requested to permit him to join the 2019, but here the individual has neither attended this office from 6/9/2019 and authority orders for issued to relieve him, but he requires I stated. As the individual was joined for duty, the individual has not released the individual. Further submitted that the individual has submitted explanations requested to do justice, but he has not submitted any joining report on 1/12/2020. In view of the above, he submitted that he shall on nationally to this office on 11/7/23, and it was expected him to submit joining report for taking further necessary action. In spite of between instructions to submit the joining report, the individual has rejected to submit the joining report, which shows his thought towards his duties and also shows he interested to join duties. Meanwhile, this was reallocated as per GO 174. It might be commissioner report, but this was
You say you are also making the payment of salary. Then why you are not relieving? Why are you not permitting him to join and then relieve him? You are not taking any action for his unauthorized absence. Have you issued any charge memo?
that is pending.
What have you done?
Show cause notice is issued. I'll submit one point. Show cause notice is after my representation because they are not relieving. I submitted representation. After a long time, they issue a show cause notice. I submitted a reply to the show cause notice. Because they can take any action on the show cause notice, whether unauthorizedly absent or not, that is subject to outcome of the show cause notice or making action on that. But primary duty of the respondent number 5, that is the district collector, he has to first take me into service, then relieve me, then implement the orders of the commissioner. He has to give me the relieving order and give me promotion order. I have to be promoted to MPO Mandal Panchayat officer. They do not implement this. After 3 to 4 show cause notices were issued by the commissioner, the DPO gives the reply. 4 notices are given without lordship may see for a moment.
On 6/2/2021, one show cause notice. 26/5/2021, another show cause notice. 7/7/2023, another show cause notice. He won't reply to the show cause notice. Finally, on 19/7/2023, he says that the petitioner is not available. I already gave a joining letter on 5/9, 5/9/2019. I already gave a joining letter with medical certificates. In fact, this is also not an unauthorized action because when I was absent, I immediately sent a leave letter to the concerned authority to speed post which have filed below. My tracking report is there, speed post is there. Even considering that I am unauthorized absent, he should first take me into service. Now, yesterday, on Saturday, they issued me a new memo. They directed the petitioner to join District Collector Kamareddy below. They say that in fact,
You have been allocated to Kamareddy.
no, they say that I should go and join report before District Collector Kamareddy, which is
Why?
They don't give any reason.
They have stated here that now you have been allotted to Kamareddy.
Now, I should be promoted, I should be allotted in the post of MPO because my proceedings are already there. I have given.
First you have to join, you
Yes,
have to
because-
get relieved, then you have to join the promotion post. Only then you can be considered as promoted.
Without, in fact, once I am promoted to the post.
Why are you not attending the duties? 2019 onwards.
Yes, my lord.
We are in 23. For 4 years, you are just going around without doing any job, but they are paying you.
No, my lord.
I can't understand why you are paying.
My lord, they are not paying a 7 rupee, my lord.
They have said, as per the pay of the individual, it is submitted, the salary of the individual has been paid as per his eligibility, and there is no pending salary to be paid to the individual.
My lord, my instructions is that, my lord, not even a single rupee is paid to the petitioner. My lord, especially my prayer also, my lord. Requesting for the salary also. Salary is not given to me. Let them show the relevant documents, my lord, that they have paid the money. They are receiving this court, my lord, no single penny is paid to me. Why will I accept that, my lord? Lordship may see this memo. Now they directly, they say that as per GOMS number 3/7, allotted to Kamareddy. I was not given posting. You don't allow me to join the post. You give me as per 3/7, you give me a letter. Now, my lord, my submission is that, my lord, when I am given a promotion order as MP, I should join as MPO. Either they should cancel that promotion order, then demote me, then ask me to join as Council Secretary.
You are on leave. First thing is you are on leave.
Yes, my lord.
During the leave period, you are promoted.
Yes, my lord.
So the promotion order to take effect,
Yes.
you have to first join your post, take the promotion order, then go and join the promotion post.
Yes, my lord.
You can't say that you permit me to join as a promotion promoted candidate. How can that be?
My lord, what will happen, my lord? I join. Then again they will track the petitioner to the court. They won't implement the promotion
So
order.
what will happen is another thing. But what should happen also is not happening. You are supposed to join in the post in which you are working.
Yes.
Then take the promotion order. Then go and join the promotion post. You will say, no, you have given already promoted, I'll join only the promoted post. How can that be? What is the rule position? Tell me.
Lord, I have to first join the post, my lord.
In which you were
Yes,
working
ma'am.
earlier.
Yes, ma'am.
After that, you receive the promotion order.
Relief
Then
order.
then you will be relieved. Then go and join the promotion post. This is the procedure, right?
Yes, my lord.
Then why don't you follow that procedure?
My lord, but payment they did not do it, my lord. No single penny is paid to me. Let them show the relevant documents, my lord. When
All
they-
right, that we'll consider, but at least now, see, you are asking that you should be allowed to join your promotion. According to them, they have allotted under 317, you have been allotted to Kamareddy.
But as Council Secretary, grade 1, my lord. Lordship may direct them to consider my promotion, my lord. Lordship may dispose of my repetition. Now they have directed me to join office of District Collector Kamareddy as Council Secretary, grade 1. There, I will join, my lord. Immediately, they have to give me a living order as well as a promotion order. Lordship may record that submission. Because, my lord,
So what happened to the promotion order? You said it has been returned. He was not there, so you have returned, sent it to commissioner. So what happened to that? How it won't get lapsed, no?
My guidance is the inspection hardware,
Mm.
the middle of the. After the joining without pillar, but the individual has neither attended his office for posting from 6/9/2019 and already orders were issued to relieve him by the regional cited as the individual was appointed from duty. The NPDO has not relieved the individual. Further submitted that the individual has submitted his explanation to the local court.
requested to justice, but he has not submitted any joining report on 1/12/2020. In view of the above, it is submitted that the petitioner, Justice Secretary Grade 1 was called personally to this office on 11/7/23. And it was instructed him to submit the joining report for taking further necessary action. In spite of issuing instructions to submit the joining report, the individual has rejected to submit the joining report, which shows his gross negligence towards his duties and shows he is not interested to join.
Milord, when I already gave a joining letter, they are again insisting me to give another joining letter. The Lordship may say for a moment, Milord, 5/9/2019. Lordship may say page number 40.
No, no, what happened to the promotion in order now? Is it there or is it not there? Have you cancelled it?
After reading the instructions, I said, asked them to submit the rule position also. Because in the promotion orders itself states, so that the promotion will be effected within so much. Because these are the rule position, the instructions are not right. As they have stated, they are ready to, in the paragraph they stated that they let them be joined the report. The subsequent steps will also be followed. Let him have the opportunity to join the.
Milord, they have made very clear. They got
showing that he does not.
So, if you don't, no, you tell me the rule position, what they will do, what they will not do is another thing. What is the rule? You are not supposed to go and join your duties.
Yes, Milord, but they
Then
should allow me, Milord. They allow me and join.
they have issued you a memo now to join in Kamareddy. You don't want to join,
I want to join, Milord.
then go and join, go report.
Lordship may say for a moment, page number 40. For a moment, Milord, I got earlier. Lordship may say page number 40.
Yes, 42, what does it say?
Lordship, Milord, serial number 2, T. Balram, he is the petitioner. He is reallocated to District Sangareddy as Mandal Panchayat officer. The Lordship may see the below paragraph. Therefore, the Mandal development officers concerned Mandal shall relieve the concerned Panchayat secretaries grade 1 immediately with the direction to report before the district collector concerned district shown at column number 6 of the table. On the same day, I give a representation, I give a joining letter. Now they cannot say that I was absent, I was not present. On the same day,
They say you have given a letter, but then you did not appear. Attend. That's what they say.
Page number 43.
Yes. You have given a representation, but you're not attending the office. That's what they're saying.
No, Milord, they have not allowed me to join. They don't give me, when they don't give me joining letter, how can I join the duty?
Or not, you file a counter affidavit, then all these things will be decided. In the meantime, you go and join.
Yes, Milord.
Though the learned GP has obtained written instructions, though nothing, the learned GP has obtained. In the meantime, notice order for that. Okay, notice to correct. And in the meantime, the learned counsel, the petitioner is directed to join.
Kamareddy. Next, as per this memo dated.
Join the service at the new local station allotted to him by memo, and as per the directions in the memo dated 16/10/2023. Let him join and let him receive.
Pay my salary, Milord. They did not pay me salary.
So it is stated that they have paid his
No,
salary.
Milord, it is not paid.
First join, you will see everything will follow. You don't want to attend the office, you don't want to do the duty, but you want the salary, you want the promotion. What is this?
Milord, I have shown my bona fides. I have submitted my
Show your bona fides by going and joining and working.
Milord, I have submitted representations also that I.
What representations?
Lordship may see representations. Showcase notice also issued to them. They are not allowing me to join.
Let us start at 2.
Item number 16, Hanuman Rao, Chief of Panchayat and Rural Development.
Petitioner's husband died. He is seeking compassionate appointment. For which one the issue memo, page 61. And last time I said similar order. Page 61 saying that the mother-in-law and the family members should give a.
No objection.
In certain circumstances. Now she is the only one that eligible. And she is also qualified. High Court is to issue writ order. One is the final, the actual response not considering criminal petition.
Yeah, how did the, I
To
think,
any suitable,
no, how did your husband die?
but he committed suicide.
Yes.
Page 61 is the memo. Where they say no objection of the family members.
No case has not been registered? No case?
Unsummoned if under suspicious death, not consent for registered.
Not against you?
No, against the family, brother and mother
Mother.
of the deceased.
Yes.
Let them consider the proceeding because the orders pass by me. Yeah, she is the only.
Order, take.
Hmm?
I believe that he is there.
Interim order, yes. Banda Sunita.
That case will not. Affidavit they have stated that with regard to monetary relief, they are giving to the mother-in-law.
This.
First, maybe some sort of.
To declare the action of the respondent not consider the claim, so and so. And it's suitable to.
The grievance is not the kind thing.
One minute, sir. Learned counsel states that the petitioner has specifically asserted in para 10 of the writ of affidavit that she is ready to share the death cum retirement benefits of her deceased husband with her mother-in-law as per her share in accordance with the rules. Therefore, to consider your
Here is the case, not the mother-in-law is getting pension of the father, husband. The husband's job was given to the petitioner's husband. Petitioner's husband also died within 2 years after the death of the father of the petitioner's husband. Now she is drawing the pension. Pension papers also, and she is drawing the pension also of the original father, husband.
Have you made your mother-in-law as a party here?
No,
Why? Is the rival payment?
no, there is no claim because.
Claim in the sense she is objecting to the this one. No? So what is the reason?
The only.
And you don't want to go and approach her and get a no objection.
And what submission is now 170 because of unnatural death. Now she is drawing pension. The other son is also married and he is also doing independent. So she is the only dependent of her husband's permanent job. So as per this order, even as per the rules also, no objection is not required. No objection.
Why they are asking to use the no objection?
Page 16.
Show me the rule where they say no objection is not required. Under which no objection is required, not required.
Under which rule also, in the memo also, they don't.
So we'll ask them which rule, under which rule are
asking?
Insisting for an NOC from the family members.
No rule says.
Let them show the.
It is the father dies, other family members and the wife have to give. Now this is a case where she petitions the wife and having 1-year-old kid. And there are no dependents except this petitioner. In the case of the death of a father, not the no objection of the other family members to give. But in this case, they have given no objection here. But that also I have filed. Lakshmi Kaisi, page 135. Page 135. When the mother-in-law of the petitioner died, but the mother-in-law and the other son have given no objections affidavits. Page 135. We make a Lakshmi, great Anjaya, so and so. That the deponent one is the widow of the deponent number 2 is the son of the data. So and so. Anjaya died on 22/11/45. Due to his death. And his son Mekala Shivakumar is the applicant for providing a job to him on compassion ground. We hereby jointly and severally declare our no objection for giving a job to him on compassion ground. We hereby declare that we shall not dispute this declaration and we will abide by the declaration. So this was given.
So under which rule are I asking the petitioner to give no objection of the family members?
She is the only defendant. Then consider the reference.
Yes, that is standing counsel for which the Thursday? Thursday, huh? Monday.
So Monday are not. Yeah, not Monday is holiday.
Monday is what? Tuesday.
I'm Tuesday, right? 17th.
17th.
17th
It
or-
is Friday. 17th, 20th.
Okay.
20th.
Number 61, Sridhar, Praveen Kumar.
Yes. Counter file the
Counter file.
and it was
Presentation was discussed. Hereafter, I filed a lot of.
amendment of your play.
Because in the representation in the.
Yeah, 1 of 23.
I will submit few facts.
No, what is that? Let us see. What of why one? I have 1 of 23. What is this IA 1 of 23? Promotion to the petitioner on the basis of resolution of the 20th meeting of the government of. Sir, approved by the correspondent, passed it on.
To understand this matter, I mean, the petitioners are the employees of third responder.
Who is the third response?
Third responder is CDF.
Okay, CDA.
Research Institute.
Yes.
The first responder has created 16 autonomous institutes for research and development in the fields of science. And this institute is one of such institutes. Out of 6 institutes, the NII is the one, first one. National Institute of Immunology.
Which one? Achha.
This is the first institute. It was, I think, thereafter, the respiratory institute was smaller. And they, all the three institutes have staff divided into 3 groups. One is admin, the second is technical, and third is scientific. All 16 institutes, they have their own recruitment rules. And the third respondent has adopted the recruitment rules of NIH. In that recruitment rules, all the staff, scientists, admin, and technical, they have promotion avenues. For every 5 years, they will get promotion. Like that, the admin and scientific cadre get given promotion, so the technical cadre was not given promotion. Adopting the rules of NIH, the technical cadre was given promotion up to technical staff number 2. Second stage promotion. Thereafter, they stop promotion, citing that there are no promotional avenues. What our contention is that when we have adopted the rules of NII, which is approved by the governing council of the third respondent, by the second respondent also, not giving promotion is and we made a representation to the second and third respondents. That representation was disposed by the third respondent.
Saying what? What is the reply?
Still, Lordship, 13,623, this is a letter addressed by the second respondent to the third respondent.
13.6.
Para 5, Your Lordship. It needs to be stated in ambiguous terms that the entire service matters of all officers and officials employed with the CDFT, including the petitioners in this case, all under the exclusive domain and purview of CDFT only. It being an autonomous institute, isn't that the CDFT had earlier considered the case of also granted his to a technical officer briefing
year 2010. The Department of Biotechnology may neither maintain service records of PDFP officials nor deals with their respective administrative matters like service with each services. Similarly, the Department of Science and Technology is a proposal of content and not complex to consider the result content. They say that we are not concerned with the service matters of the third respondent employee. To answer this matter, they have disposed of my representation, the third respondent. Stating that they have respected the promotional rules, they are awaiting for the approval of the second respondent. The second respondent says, I am not concerned with their services. Third respondent says, we have again adopted restructured promotional rule and they have to be approved by the second respondent. In that confusion, I find the IA asking them to consider my promotional avenues. Basing on the governing council and on 6/7/2010, which is on page in the lordship of page 21, it along with IA 1 and agenda, your lordship of page 24.
Yes.
The government also noted that CTRT has been following the NIA rules and regulations. It recommended that the NIA rules may be adopted mutatis by CTFP and there will be henceforth referred to as CTFP rules. They have adopted the rules of NIA. Promotions have to be given as per the rules adopted by them. Now, they 2010 technical promotion. After 2010, for the 13 years, the technical staff are stagnated. There are no promotion. What they say is in 2015, the audit people have raised some objections. Because of what objections, we are not giving promotion. Now it is for them to clear those objections raised by the audit team and the promotions to us.
So actually counter affidavit is only filed by respondent number 3.
Yes, ma'am.
Respondent number 2 has not filed any counter.
They say that we are not concerned
with the service matters. Now what about respondent number 1?
One is
Government.
Ministry of
government to the state.
Okay.
For the past 30 years, no promotion. They are on the same level. Whereas the admin staff and scientific staff, they are getting promotions. Let second respondent answer them. He is the person who has to answer.
But your prayer is to give promotions on the basis of the resolution of the second 20th meeting of the governing council. Let them come forward with some reply to this. Yes. I have 1 of 2026. What is your quote of this?
Rapport master, Srinivas, Vishwa Prasad. Your right confidence.
You have not received the copy of the petition. You send the notices by RPAD. And give the copy to her. Give the copy to her. The Leonard Council representing this respondent number 4. Submit that she has not received the copy of the resolution.
70 years. Yeah.
son of the patient was murdered by the respondent of one. Basic of the incident, the case has been registered and remanded in the judicial function. While the kids are there, the kids are playing with the patient. The other will be taken danger. But the patient are approached the Calcutta.
Approach whom? No, petitioner approach whom for maintenance?
For number 2 and 3.
Ah.
Made representation to grant the death penalty. And son of the son and daughter of the deceased man. They are not initiated to pay. Meanwhile, they filed the counter. Their counter already will be still they submitted certifications certificate. As per their own counter laws, considered the process. The petitioner is submitted the entire documentation. They will release the funds.
You can release the funds with regard to the children. All of, there are 4, see, one person dies, there are 4 dependents. Mother is also a dependent. Children are dependent. Wife is there. Withhold only the wife and the parents you can withhold. Yes.
No, in almost all the nominations forms, my lordship, the spouse is the nominee. Nowhere the mother is mentioned as nominee, my lordship. Now, one more thing, my lordship, this situation is filed by the mother, my lordship, without making part of the minor children represented by guardian. So she only claims the benefits with respect to her. The nominee, the minors are not being made party here. That's why one more submission. The requisition document submitted to the R4, my lordship, it's a claim between R4 and petitioner, my lordship. They will come out with the quantum, my lordship, then the matter will be heard.
Why did you not make them parties here? How to accept your condition that they are living with you or not with? Where are the children? Are the children with you or not?
My lordship, it has submitted a letter dated 11/2023, stating that the children, the mother claims the children with her.
You give the papers to me after 2 weeks.
Item number 63, Rahul Bhaskar, reactionality.
63 to 68, I think that connected. Yeah. Already it was heard. And
yes, sir.
So these are also CAB.
Now they were selected you get a full person confident was ignored and given problem in 19 have been selected focus survey company and just because it's a statutory technical force it cannot be substituted. Those two were ignored seriously used because only 2 were selected in 2020. 19 were selected, 19 surveys go from the company to another. There is no violation of what is 14 would not arise because there is no favoritism or only for the 19
Alright, consider. Reserved.
Item number 69, Venkat Raman, equipment assignment.
Very jurisdiction of the fundamental we can stage the petition. Wherein the counter has also been filed, this is the second round of litigation. Wherein the Honorable Court has directed to refer the appeal. Wherein the appeal has disposed of without considering the issue whether I am concerned that the definition of the workman or not. The process may totally affidavit law. I have narrated section and as well as the provisions regarding the very same. They have taken the action with regarding to the standing orders of the company. Wherein the standing orders itself states that
The workman definition.
No, if they have filed a counter. Yes. You don't want to file any DPO on that?
No.
I saw. Then, yes. Huh? Sorry? You are not.
Short date.
Next week. Next week.
Take action.
Yes. Then what time? Is that section of the list?
Item number 70, Venkatraman, Chief of General Administration. Reaction.
Investigation process has directed them to get the instructions where the petitioner was getting the scheduled caste or hails from the Andhra Pradesh. But he has been working in this very company before the bifurcation. In this regard, this honorable court has already passed an order. Have actually the very same to the affidavit, which is in page number 33. The operative portion. In this regard, the lordship has asked them to get the instructions.
Page number 33.
Page number 33, para number 45. This is the circumstances. The petition is allowed the respondent number 7 to 11. The directed to pay cost of 50,000 in 4 weeks, and the action of the respondent number 7 to 11 in not extending the said benefit in the 2022-2021 held in November 2020 is declared as illegal in stock of so they are directed to consider the case of the petitioners for promotion to the post of Deputy Chief Medical Officer as per the orders GOMS number 5 of the Social Welfare Department. And this GOMS number is 5.
Were you parties or were you?
No, we are
similarly placed.
Similarly placed.
So have you made any representation?
The representation is in the page number 24. My juniors are getting commission. That is the reason. Previously, I have placed above them, and later on, I have placed below them.
Yes, you want this to be disposed of? On your representation to be disposed of?
Disposed of in accordance with the because already this court has passed various.
Yes. The petitioner is seeking a direction to the respondent. It is a court.
The next minute, lordship has directed to mentally retarded person as a petitioner. I have filed the petition with her. Will be taken up next week.
Next week. Yes, next.
Item number 72, Venkatraman, TSHC.
It's a matter without seeking to
For re-medical exam.
medical program. Have made the representation also third page number 25. Last occasion, lordship has asked them to get the instructions regarding the very same. I'm asking to dispose it of in accordance with the circular passed by their own company.
What is this circular?
Circular is in page number 27 to 28.
The revised application to be submitted 28/20.
Yes, yes.
The revised application to be submitted by the employees who are intending to the CMB corporate medical board for arranging medical examination by the corporate medical board. This happened now. First I have I was examined by them, but they made me as a fit to the same job. And after that I have made the application and they are not considering. What I am asking is them to consider my application in accordance with this circular.
Where is the revised application?
Revised application method is page number 25 method.
Is there any pro forma for that?
There is nothing like that. No specific performance. Yes, and maybe is corporate medical.
Yes. 28. Annexure 1. What is that annexure 1? So where is that annexure 1? What does it contain? Annexure 1. With the same details, then you can consider this as application for this one. Refer him to the material. By Monday, next week. With the request of the London Standing Council to get instructions in the matter. Yes, next week. The same day. Budget.
Item number 73, P. V. Krishnaiah, Jitendra, Raj Praveen Kumar, Pankaj Reddy.
These are coming for inspection. Yes. You filed a stay vacate. What was the interim direction? The equivalent order is supposed to have been passed without recording in this as to what is the public interest involved. Hence, there shall be instant suspension and stay in court. All right, I'll take up at 2:30. Take up at 2:30 for hearing. Whatever the stay vacate, we'll have to take up. Yes.
Tomorrow.
Pass over. Huh?
Tomorrow.
You want tomorrow? I'll let tomorrow.
Yes. Item number 74, Chela Gururanjan, GP for Labor.
The stay vacate file. Yeah, pass over.
Item number 75, Srikanth, Gadi Praveen Kumar, Umadevi, Annapurna Sriram.
They are appearing for R4 and R5. Annapurna. Okay. There is a stay vacate petition, ma. I thought raise the date. You are appearing for Umadevi. You have not finished. All right. The interim order is granted earlier. It's been extended by a further period of 2 weeks. We started immediately.
Item number 76, Sai Prasen, GP for Services, GP for Land Acquisition.
What question then, have you filed a thought? No, it's coming for extension of interim orders. Huh? What is the interim order? Total number of posts. Additional seeking a direction not
They
to
do not want to pay the compensation to record it, I am ready to come. Really got it. Counter the order for instructions and file counter. Thereafter again matter came class certification, we got it that file counter by 6th level. Let them file it. I don't know why they are setting that was to on the basis of.
See, I am not going to vacate the interim order only on oral submissions. If you are going to file a counter, file it, I'll give you time. Or you want to submit, but for what purpose you tell me.
When we start for the basis of instruction, we start the production was not in the court and co-occasion. But if you crossroad this value stage was not available and it's for
whatever happened, we'll see that later. Now first. Passover, there are other two matters. Stay vacant petitions pass over, Mr. Sudhir's case is passed over. How many cases can be taken up? I'll post it after a week. Meanwhile, file your counter also, then the matter can be heard. Once and for all. Okay? A simply modern and regulation stand extend by a further period of 1 week. The response to file counter is after 1 week. File your counter, that will be better. Yes.
Item number 77, Praveen Kumar,
Adhikar, we interim orders extension తీసుకుంటాము అన్నాను కదా బిజినెస్ లిస్ట్ ఈ లిస్ట్ తో పాటే తీసుకుంటామని చెప్పారు అంటే తీసేసుకుని లేదంటే
item number 89, Rahul Reddy, Chief of Medical Health, Ram Gopal Rao.
No, stay extension. In the morning when they mentioned, I said I'll take up along with these petitions. Extension of the stay petitions. Now, Nara, let's okay, call them. Call chain, normal list calls.
Item number 77, Praveen Kumar, Alakshamurthy.
One minute, sir, to verify the trial court record, office is directed to call. Okay. Including the service of notice record. I will explain. Since the record is here, it has to come here. I'll take up tomorrow. Let the record be here. Okay? What? The record's a picture. All right. Interim order granted earlier shall stand extended till tomorrow. I'll consider tomorrow. I'm extending it till tomorrow. If the matter is not reaching or something, please mention. I'll extend it.
Item number 79, Shanta Masatran, Chief of Services.
The request of the London GP, Friday. Compliance has to be in full only, can never be part. So let her do it. Give her some more time. Yes.
Item number 80, Ramesh.
Notice has to be.
Hmm?
Notice.
With that notice? What is it?
Honestly.
अच्छा notice order check no representation में व्यवस्था
Petitioner.
on behalf of the petitioner. Okay. First time in this. All right, notice. What is the direction? Permitted to make an online application for survey of their lands. Did you make the application?
Yeah, minutes. Page number 25. Yeah.
Page number.
23. Is there representation?
No, online application. You are supposed to make online application.
Page number 26. There is mentioned that 2370105108 online application number.
Visa application. All right, notice. Just after 4 weeks.
Number.
By showing notice to them, let them come and say why they are not responding. Yes.
Item number 81, Allahabad, Udai Street.
Yes. Let him on, or give his case.
But they have issued the input data data. The 5 regions issued the input data.
What is that page number?
Page number 22 and 23.
Ah.
22.
Yes.
The petition number 23. 3055. Wherein you have the petition number in our viewer favor. In this case, this petition was filed for the issuance of gate passes. Thereafter, the respondents will consider the two petitioners except the petitioner. This petitioner.
No, where is that petition filed by you? 3005 of 2015.
I have filed the copy.
Yes, where is it?
Page number 45. Yes,
45.
45.
This is petition number?
Yes. 3055.
No, 45 is WPSR 17058.
WP number.
Right. SR number.
This was not filed for issuance of gate passes. Thereafter,
Where is your name here?
the name is your the appendix page number 47.
Can find a written affidavit?
Copy of the written affidavit. Okay, these are from the case. So here your name is. Your name is on page 47.
Page 47, item.
Okay. Yes.
We remain
Thou.
Thereafter, the respondents will consider the above two petitions. The present petition, they have issued the input order. That's for that reason they have been done. Now the second round is that the petition filed the IA number for amendment of the cost center. That was ordered on 8/11/2019. I have filed the copy of the order 24, page number 20. Page number 24. Order 25.
No, repression copy, order copy is also there at page 42.
This is not there.
But the court would have recorded, see the third petitioner is B. Ramesh, son of Daud. Order copy it is there. 42, okay. Then you file IA?
For amendment of the name was.
Where is it?
This is the IA number, IA page number 27, IA copy I have filed. That was ordered on 8/11/2019.
27.
Page number 27.
You are G. Ramesh, son of Bicha.
That is the fifth respondent. The below B. Ramesh, son of B. Ramesh, son of
This IA petitioner is one Mr. G. Ramesh, son of Bicha.
Yes, the petition copy in page number 29. I submit that I am requesting this honorable court to correct, modify, amend the constitution as G. Ramesh, son of Dabu instead of G. Ramesh, son of Picha. Page number 29, sir, para number 6. Petition card.
No, why, if, in the earlier order copy of dismissal, is withdrawn, it is mentioned as Ramesh, son of Davu only.
Yes, so in that, the petition in the earlier in the year 2012.
Subsequently, you filed another petition.
2012, they have filed a petition.
For what?
For not to discontinue the petitioner as a contractor.
So their name is wrong mentioned as
Item number
G. Ramesh, son of Bicha.
Yes.
But 8 also is mentioned as 23. Whereas here.
Page number 32, the copy of the order. Page number 32, also that is last. Page number 32. This extreme direction was granted. Serial number 8, G. Ramesh, son of Bicha. In the order class. In the side Miller, B. Ramesh, son of Dav. This was got amended Miller order on Miller. Page number 27. Page number 27, the copy of the petition, and also page number 24. The petition was amended and ordered accordingly. The respondents continued to the respondent. They are continuing. Not only in the equipment order also, you also can pay item 3, round number 3. B. Ramesh, son of here also, they are right to always confuse the things. Instead of G. Ramesh, son of again, B. Ramesh, son of.
Okay.
They are continually trying to confuse the case. Always mentioning instead of B, G, instead of B. In the ground number 3, B. Ramesh, son of Bicha. Actually, that is G. Ramesh, son of Bicha. Whereas the petitioner serial number is 8, in the WP number 360904 was already continuing in terms of written direction. WP numbers also in under CC number 41 of and later he was observed as in terms of memorandums also. Here they have observed B. G. Ramesh, fifth respondent. Here also initial mentioned as wrong. Instead of G, they have mentioned B. Fourth ground is therefore at the length of time, mere replacing of your name in place of B. Ramesh, son of here also initial B. G, they have to mention that. Son of Bicha by order dated 8/11/2009 does not confer any benefit of order passed in 3690 of 2012 prior to the amendment of the last state. But in earlier repetition, there was only mentioned. That was the got amendment. Thereafter, he was reported. In the meanwhile, the fifth impersonate person, fifth respondent, he was taken into, he was observed. Now, he is continuing his service. Notice was also served upon him. I am seeking direction not to continue the petition. Is the disposal of the repetitions.
Not to continue the respondent number 4.
You have
You have not filed your counter affairs?
They are filed.
Okay. Yes. Unda?
I have come.
Huh? Counter is added.
I stand corrected. Counter is not placed on record. Because we were required to translate the Telugu version in English. He made a presentation in Telugu that he has not filed. I wanted to file it, but now we can correct. Telugu counter.
The interim direct amendment he was submitted in representation. While explaining the situation and also got the rectification order amendment.
Now, what you are following is the direction, interim direction of this court in WP 36904.
Yes, I just narrate facts.
Good.
2012, there is a repeating. An interim order is
That's not kind of thing. Continue.
Please. అదే దానికండి ఒక్క నిమిషం నేనేమన్నా ఆన్ చేసుకుని కూడా చూస్తాను
finish your hearing. Item number 81, Allah Udeshri.
The compass. That's all. Yes, sir. Yes.
Within WP 36904 of 2012. So one is the petition number 8. Is the main son of picture in the party with the proceedings.
Yes.
And there was an interim order granted at page 14. In view of the orders in similar matters, status quo as on today shall be maintained with regard to continuance in service of under the same terms and conditions under they are working. Then the consent case was also initiated at page 15. The court recorded the things we have been continuing, they are being continued. Page 16 not Since the respondent has undertaken to provide the work to the citizens in the most efficient manner, I am not inclined to proceed against the respondent. The respondent has evolved a scheme of absorption of the persons who are working on contract issues. In terms of the settlement and the orders by the department, page 17, memo dated 29/8/2017 was issued. To the petitioner number 8 in the WP 36904 of 2012, observing him as an artisan. That is at page 17.
Yes.
Now, when the petitioner contains that there is a change, I have sought for, that is at page 19.
Yes.
This is a amendment section sought in IA 1 of 2019. WP number saying that respondent petitioner number 8 name should be amended. This is on 2019.
Yes.
By this date of 2019, the petitioner number 8 in WP 36904 of 2012 is already observed by proceeding dated 29/8/2013. Then he makes a return, then he withdraws a requisition which he has filed at page 22. That message is relief sought for in WP 3005 of 2015. Petition under 226. Please issue a writ of mandamus or any other so declaring the action of the respondent voluntarily not issuing gate passes to the petitioner's hearing, though they are contracted as illegal so and so. There he refers to his name as B. Ramesh, son of Dao. Whereas in petition of 2012, his name is B. Ramesh, son of Mitchell. So admittedly, he was not working in 2012 or 2015 or thereafter.
No, initially when he filed WP of 2015 of 2012,
he is filed by one Mr. B. Ramesh,
son of Bicha, then got amended.
No,
IA 1.
IA 1 is in 2019.
19.
By the 19, he filed a 2015 mandate petition with a different name.
B. Ramesh, Tahu.
No.
One minute. Please. B. Ramesh has filed petition 3005 of 2015.
Petitioner in the 2012 is not B. Ramesh.
So when was that amended?
2019.
It was amended in 2019. And the repression was withdrawn in 2020.
Yes, sir.
So petitioner who filed WP 3005 of 2015 is the petitioner here in this repression.
He got substitution in 2019. In the WP 2012. By the date of that substitution, the persons who were working in 2012 restrictions have been observed. So he will not get any relief by virtue of his name being substituted in the place of 2012. Because now the absorption scheme has come to an end in 2017 itself. So
I cannot substitute his name. Purely because he may sought for an amendment of class 5 petition in 2009. Then he makes a representation. Interesting, you had a representation also. Page 21. This representation is another person is working. He should not have been working. I should be appointed. But that episodes have came to an end because the only persons who were working in 2015 alone are eligible for absorption.
2000?
2000, that is the regularization orders at page
17, 2017.
Yes. This DG over 216, 217 are applicable only those who are working in the at the relevant point of time. Admittedly, 2017 he is not working. Now by amendment in 2019, he can't say that the person who is observed should be. Now, let us see what is the interim order relief he is seeking for. He is not challenging his appointment order. Prayer is declaring the true date of the 1920 and declaring the consequently direct the respondent to remove the seventh respondent. He does not challenge his appointment order.
Absorption.
Absorption order. Where is removing him now? By granting benefit, but even for a moment assuming this gentleman is not entitled for absorption in 2017, the petitioner would not be entitled because scheme contemplates only those who are working at the relevant point of time. Our High Court has affirmed that settlement, saying that only those who are working as on that cut-off date alone are eligible for absorption. Admittedly, he is not there. Therefore, he can't now seek a direction to absorb him in place of respondent. At the most, he may go. He will say that they were not. But even he would not go. Because even every person who is working in my organization as on that cut-off date have been absorbed. So whether his name is properly there or not is only a
He is the person who got the order. Anybody else?
controversy in 2019, not earlier. Because in the petition in 2012, till 2019, he did not say that I should be named as so and so. So 5 long years having kept quiet. Or 7 long years. And absorption proceedings have culminated in the issuance of the appointment orders. Now that even if he gets something against the fifth respondent, he would not get any relief because he is admittedly not working as on cut-off.
So what you are saying is, even though there is an order of 2012 to continue, he is not the one, the other person was continuing. Continued, and where you have observed his services in 2017.
Yeah, he acknowledges in his representation in 2020 also that that gentleman is continuing. Let me see the representation at page 21. Paragraph 4 lines I will read. Starts like this. తప్పుల సవరణ కోసం నేను హైకోర్టులో కేసు వేయడం జరిగింది. పేరు సవరణ కోసం తిరుగుతున్న సమయంలోనే ఇది నా పేరు అని జీ రమేష్ తండ్రి పేరు బిచ్చా అనే వ్యక్తి నన్ను పనిలో తీసుకోవాలని హైకోర్టు ఆర్డర్ను తప్పు పట్టించు TSHC గారు ఆశ్రయించారు. అప్పుడు నేను కూడా వెళ్ళి జీ రమేష్ తండ్రి
No, I think you read from the second paragraph.
Yes, sir. Yes, I will. Case వేసుకున్నాం. I will read from right. So, but I read. నేను అనగా I read from.
Beginning.
నేను అనగా so పనిచేశాను. ఇందులో భాగంగా BTL-CCA లిమిటెడ్ నెంబర్ నవంబర్ 2012 సంవత్సరంలో 18 మంది కలిసి మీడియా అండ్ 15 మంది ఇతరుల పేరుతో హైకోర్టు 18 మంది మామూలుగా సర్వీస్ తీసుకోకుండా
కాకుండా మరియు కాంట్రాక్ట్ లేబర్ వృత్తి కల్పించక కొరకు హైకోర్టులో సీసీ నెంబర్ సో వేసి ఉన్నాం. ఫాలోయింగ్ ఇయర్ his name is not there.
In 2012.
Yes, sir.
That's where he got amended later.
So,
But
no, so there is, you not
there may have been a mistake there.
No,
At that time.
There cannot be a mistake in the surname and a mistake in the father's name. There is a difference. It is not that his name is, let me see what is the name reflected is G. Ramesh son of Bisha.
No, in the petition, it was not mentioned as G. Ramesh. It was mentioned as B. Ramesh.
G. Ramesh son of Bisha, page 13. I can't go by who is that person. Still number 8, G. Ramesh son of Bisha. So this person is continuing. So this representation, he cannot say that I was G. Ramesh son of Bisha. It is not his case also. His case is I am B. Ramesh son of Mukya.
Bhav.
Son of Bhav. Now,
Thou.
so you can't now make a representation saying that 2012 or 2014 contempt is I am a petitioner. Till you came into the picture in 2019. Then he said that document is continuing, he also records that in his representation. Now, I'm a but the case I put one for her was he can't ma. నేను అనగా బోక్యా రమేష్ తండ్రి దావు నా పేరు బదులుగా ఇంటి పేరు జి రమేష్ తండ్రి పిచ్చా అని కంప్యూటర్ లో తప్పుగా ఎంట్రీ చేయడం విచ్ కంప్యూటర్ పిటిషన్ ఆర్డర్ వచ్చిన తర్వాత కూడా నేను మార్చి 2016 నుండి ఏప్రిల్ 2016 వరకు పనిచేసాను. ఆ తర్వాత తేదీ నుండి 16 మందిని పనిలో తీసుకోకుండా ఆపివేయడం జరిగింది. తిరిగి సెప్టెంబర్ 20, 2014 సంవత్సరంలో తిరిగి పనిలో తీసుకుంటామని మా ఇద్దరిని డిఈ జయరామ్ సార్ పిలిచారు. గేట్ పాస్ జారీ చేసినప్పుడు నన్ను అనగా బూట్లే రమేష్ తండ్రి దావు అని పిలిచి మీ పేరు బదులుగా జి రమేష్ తండ్రి జీ ఇచ్చారు కానీ ఇంటి పేరు మరియు తండ్రి పేరు తప్పుగా ఈ రిపిటిషన్ ఆర్డర్ లో ఉన్నది. దీనిని హైకోర్టులో సరి చేయించుకొని వస్తేనే తిరిగి పనిలో తీసుకుంటామని జయరామ్ గారు సో అన్నారు. ఇదే సమయంలో మా 16 మందిలో ఇద్దరికి జేపీఏ ఉద్యోగం రావడం జరిగింది. ఇంటి పేరు మరియు తండ్రి పేరు తప్పుగా ఉన్నందున నన్ను విధిలో తీసుకోకుండా మిగిలిన 19 మంది గేట్ పాస్ ఇవ్వడం జరిగింది. నా పేరు తప్పుగా ఉన్నందున సెప్టెంబర్ 2016 జనవరి 2015 వరకు స్వయంగా పొందించాను. నేను తప్పుల సవరణ కోసం హైకోర్టులో కేసు ఫైల్ చేయడం జరిగింది. బెనిఫిట్ దట్ ఇస్ ఇన్ 2019, నాట్ ఇమిడియట్లీ ఇన్ 2015. పేరు సవరణ కోసం తిరుగుతున్న సమయంలోని నా పేరు అని జి రమేష్ తండ్రి అనే పిచ్చారి వ్యక్తి నన్ను పనిలో తీసుకోవాలని హైకోర్టు ఆర్డర్ పట్టించుకుని పనిగా ఆశ్రయించాను. అప్పుడు నేను కూడా వెళ్ళి జి రమేష్ తండ్రి పిచ్చారి వ్యక్తి మిమ్మల్ని పట్టిస్తున్నాడని అసలు మేము కోర్టులో కేసు వేసిన సమయంలో కానీ తర్వాత కానీ 2011 కానీ ముందు సంవత్సరం మీరు పనిలో చూస్తున్నా అతని కేటీపీఎస్లో ఎవరి వద్ద పనిచేయలేదు. కేసు పాస్ కూడా లేదు. ఆధార్ కార్డులో పేరు ఆధారంగా తీసుకొని అతని పనిలో తీసుకోవాలని నేను వారికి చెప్పను. అప్పుడు సిఈ గారు మరియు ఎస్సీ గారు నీ పేరు సరి చేసిన వస్తే నిన్ను పనిలో తీసుకుంటామని హామీ ఇచ్చారు. నా బదులుగా వచ్చిన వ్యక్తి అప్పటి వరకు పనిలో తీసుకుంటామని వారు అన్నారు. అలాగే తన చేత ఫిబ్రవరి 2015 ఈ లెటర్ రాయించుకోవడం జరిగింది.
ఒక లెటర్ రాయించుకోండి.
ఒక లెటర్. సో 2015 he has not even approved the court in 2015 for correction of his date of birth or name. ఈ లెటర్ లో ప్రస్తుతం కోర్టు ఆర్డర్ లో నా పేరు ఉంది కావున నేను విధులు కావు. Now that there is no scheme, there is no contract ever engaged or continuing.
He says he has written in that letter that that person said, G. Ramesh said that, because my name is there, I will attend and I'll.
That is in 2015.
15.
Now situation changed. There is no contract ever now. At the most, he may go back to contract labor. There is no contract labor. That is now observed as an article.
I think he is a party here, but he has not appeared.
Because his appointment order is not understanding. How can they remove? Give a direction to remove him unless the appointment order is held in the law. Therefore, we can't see actually. As per page number 48 of the petition papers, thereafter they have ordered for
their inquiry, extended from the officer, that they have conducted a detailed inquiry. Page number 48. Page number 49, the petitioner name. P. Ramesh, son of the. This is the Miller.
What is this? This is dated to
Page
the.
number 48, Miller.
Hmm.
Established TSHC security and vigilance service KTPS 516 to follow the legal cases, furnishing deniability of the gate passes submission. Therefore, he is the denied candidate.
You approached very late. In 2015 itself, you should have got the order rectified, amended. Hmm? That's all. And No, but when did you file? You have filed in 2019. 19. After he got absorbed and he got regularized everything.
6904 of 2012, we have filed all the gate passes, everything.
But that petition is not before me.
No, I think.
Where have you filed? Show me. Which document have you filed? Page number? Except the affidavit, there is nothing there. That petition is not.
No, there is a report of the 22/1/2015.
Everything is in favor up to 2015, but he is not there in 2016.
This is enough, page number.
Yeah,
Page number? Page number?
Page number 48, the school officer himself gave the generality of the. This is enough to say that he worked as a. Page number 48 about the generality, furnishing of the generality of the.
This is 22/1/2015.
Yes, no. He said after inquiry, the assistant security officer gave the report.
Ready.
It is enough, my lord.
He is not filed.
Also, madam, number 53, Sudhir, Chief of Service, Srinivasram Madrigal.
Yes.
Want to fight?
Five.
Fight.
Yes, Mr. GP.
Yes.
Yes. Mr. Sudhir, you want to say something?
Manoj, what all I want to say, Manoj, is that we have challenged one transfer order, you lots are aware, because it was changed within a day. You lots of were pleased to suspend. The transfer order doesn't say anything, any reasons. So, Manoj, you lots have suspended. The unofficial respondent approached division bench. Division bench also affirmed the lordship's order. And when the matter came up, Manoj, I brought to lordship's kind notice that they were not implementing the original GO through which I was posted to Medchal Malkajgiri.
Yes.
Only on the ground that vacate stay has been filed by the both the respondents. And on the ground that vacate stay is filed, my lord, they thought they can go ahead and continue, my lord, the second respondent and not implement. Therefore, my lord, lordships were keen, and then my friend, my lord, GP, he referred to, my lord, 226.3, my lord, which is not applicable. And my lord, they were very much my lord, vociferous and then vocal, my lord, to say that we can continue to be violating the contempt of this court. Therefore, my lord, lordships are posted next day for the purpose of finding out what is the position. My lord, having noticed that it's not possible and then the all efforts failed, my lord, they issued a GO now. My lord, that is GO 386, which categorically says, my lord, once the 386, my lord, as per 386, my lord, the earlier impugned GO was taken further, taken off.
Yes.
And my lord, meaning thereby, if your lordship sees GORT number 386, the meaning thereby 275 through which I was benefited and posted to Malkajgiri comes back into force.
Yes.
Impugned GO is 279. Therefore, my lord, I can simply go and join just the way, my lord, he joined within on the same day. My lord, when 279 was issued without there being a fresh posting orders. But in 386, my lord, while withdrawing 279, a direction is given at para 5 that both of us have to go and meet the principal secretary. This says like, Sri so-and-so, so-and-so, so-and-so are hereby directed to report before the government for further postings immediately. Well, once the GO is issued and I'm already posted, there is no necessity for giving a posting order, but I didn't want to precipitate the matter. And I directed my client to go and report before the principal secretary in obedience of the orders passed in 386.
Okay.
And accordingly, my lord, he reported on 2/11/2023. But still, my lord, no orders are issued and a petition is still in the air.
Yes.
Lord, so far as your worship's directions regarding the consequential postings, others are suspended. Your worship's directed them to comply with the order. We have complied and recalled those orders. Lord directed them. Accordingly, Lord, both of them relieved from the old places, reported before the Lord HOD, before the government. Lord, now that the scope of filing this petition, it becomes infectious, Lord, because the orders under which were challenged were taken back. Lord, this petition becomes infectious in my first submission. Lord, regarding my second submission, the other day, one request regarding 226.3, Lord, I said before Lord that I get the judgments. There are 3 judgments on the point, Lord.
So once my friend says it is infectious, Lord, there's no necessity to go into 226 now that
my
is already set aside.
And also refer 226.3 while he is submitting before lordships.
So what all went, during the proceedings before the court?
Because it was.
If you still want to insist on 226.3, then that's it.
No, now it is not necessary. Since
There ends the matter.
My friend is also aware, he is a senior counsel, Lord. He is also aware that 226.3 there were judgments in my favor on the point raised by me. But despite that, Lord, he has said that's why I was referring to there are 3 on point judgments are available with me. I'll pass on, Lord, even after this also. So far as this case is concerned, Lord, if at all any grievance is there, it will be a separate cause of action for him. Let him ventilate his grievance regarding posting orders and other things. So far as the question before lordship is, when orders were set aside, recalled, lordship may close the petition. Please.
What about 275?
Which one?
Earlier first petition through which he was transferred and posted.
Posting, that is what, the posting is.
So earlier GO gets revived.
No, it will not get revived because this order of the government is, both the orders have been cancelled. Can you see, note the GO 386?
Yes.
Paragraph 5.
No, para 4 first.
Para 5 was present. Para 4 also.
Para 4 you will.
Now, therefore, in compliance of the orders of the Honorable High Court of Telangana,
Government after careful examination of the matter hereby withdraw GORT 279 dated so and so. This is one aspect. 279 is a subsequent order where orders have been given without giving any notice and opportunity and without assigning any reason.
Yes.
Paragraph 5 you watch see. In view of the observation made by the Honorable High Court in third read above, in partial modification of the orders issued in reference first read above. See so and so, so and so. Reference first read above also not posting orders are given to both the individuals. In partial modification of those orders, hereby directed to report before the government for further postings immediately.
So what is the modification that you have done?
Modification is not, they were directed to report before the government.
That is the modification.
Yes. Not posting orders, not, they both were directed to report before the government. So far as the suspension order is concerned, we not change of posting from Hyderabad to Karimnagar, Karimnagar to Malkajgiri has been suspended by your lordships. We have recalled and somebody else was posted in Karimnagar. So I request your lordships not let this petition may be closed not by observing.
Yes. Yes,
Yes,
I think now
yes,
as far as your repression is concerned, you are only challenging GO 279. GORT 275 you want to be given effect to. That also is partially modified. Maybe you have to challenge it. But as
No,
far
1 second. 1 second.
concerned,
My lord, may I just say this, bro?
Mm.
When the matter is pending about 279, and when I'm relying upon 275, Lord Speaker, kindly see the conduct, Lord. I will challenge it if it's required. If this is nothing but preventing this honorable court to take a decision on the illegality of giving 279, and then now 279 is withdrawn. The law is very clear, my lord. Once the earlier GO is non-existent, it automatically goes back to the 275. Now, my lord, that is the reason why even after lordship specific direction saying that he should be present, why he is not implementing, my lord, surreptitiously, conveniently changing this and then trying to avoid presence as well as all this, my lord, is nothing but, my lord, playing around with the courts, interfering with the judiciary, interfering with the judicial process. And simply by saying, I will not take anything, and you Lord Speaker, see the game plan. So they want to achieve something what could not be achieved directly, they want to achieve indirectly. I am concerned about my posting to Karimnagar, no, not Karimnagar, sorry, this place. And there is another ground I have raised. There is no answer from them that I am from Karimnagar. I raised this before the division bench. Division bench has said that has been taken note of, but at the same time, because you have not raised, I filed an additional affidavit in the present case. I am from Karimnagar, and the second respondent, my lord, is from Nalgonda. And rules categorically say, my lord, we're dealing with the transfer that a person, a gazetted officer, cannot be posted to native district. He is from Nalgonda. Whoever is posted to Malkajgiri Medchal is also, my lord, authorized under is the authority for the Nalgonda. In other words, my lord, both of us are posted to our native districts contrary to the policy decision.
Anyway,
One second, sir.
He has not allowed us to argue our counter affidavit.
1 minute. Now, transfers to Nalgonda and Medchal Malkajgiri are pursuant to GORT number 279.
Correct.
Now that the GO 279 has been withdrawn, nothing remains here. That question will come again if you are now transferred to those respective places.
No. Now by what I'm saying, I'm not. Now that 279 is set aside. Now that 279 is set aside, you Lord Speaker, see very conveniently, my lord, the postings orders are given, and you Lord Speaker, see para 5. My lord, the law is once the GO Butler thing goes, automatically the earlier GO, it cannot be a vacuum.
No, the earlier GO comes in.
Comes into force. Now kindly see para 5, my lord, for a minute.
Yes.
Further, in view of the observations made by this honorable court, that is the lordship's order, in partial modification of the orders issued in the reference first cited read above, say so and so are hereby directed to report where is the question of modification of 275? And that means that is exactly what I'm saying. When your lordships are considering whether I should be posted to Malkajgiri and all that, he usurps the power. He doesn't want your lordships to decide it, and then simply retrieves 279, my lord, which was fought tooth and nail.
That's true. You may be right. No, you may be right. I'm not saying that.
My lord, kindly appreciate, my lord. I'm your lordships are not.
No, 1 minute, Mr. Sudhir.
I'm sorry.
As far as the power of this court under 226 is, when an order is challenged, then we have to see whether it's in accordance with law or not. Now, transfer is strictly within the domain of the government. Now they have transferred, it's illegal, I have held so, and it has been upheld. That transfer order has already been settled.
May I suggest something?
Now, there remains nothing now to be adjudicated.
No, may I suggest, Lord? May I suggest? As your lordships rightly said under Article 226, my lord, it is so vast. Your lordships not just going by what is seen. Your lordships will also perceive and lift the wheel and see. Is this the way, my lord, an officer can act? An officer who doesn't respect to this court orders, an officer who gives posting orders on the same day, when I succeed on 6-9 and also in 25th 6 my lord 10, same orders are confirmed with the division bench. He doesn't give. Vociferously, my lord, some other article, my lord, my friend is saying 226.3 and all that. 226.3, I have picked up 3 judgments where it says it is, 1 second, sir. Where it says it is not applicable. Supreme, my lord, Madras High Court and dealt very detailedly that it is only directory but not mandatory. About 30-40 pages, my lord, I have taken out the judgment. But the day I wanted to argue, my lord, they came out with 386. Now, would you lordships, my lord, and this particular person, my lord, respond number 1, my lord, has the audacity not in this case. Your lordships have seen that. This is not, my lord, this is nothing but interfering with the rule of law and the lordship's jurisdiction. It is nothing but, my lord, bureaucracy trying to act too smart and then trying to, my lord, overreach the tendencies are demonstrated.
All right.
Okay?
Yes.
Now, I will say one thing, my lord, I will request one thing.
Yes.
Now, 279, I challenged. 275 was in my favor. 275, my lord, it looks very conveniently, my lord, as if I am going to be given a posting order. And now they want to get it closed. Now, now that means 275 is also modified by virtue of 386. Your lordship kindly give me day after tomorrow. I will amend my prayer challenging 386 also. I will amend my prayer because you cannot play. You are, my lord, any officer thinking that he is very smart, my lord, is not correct. There is nobody who can be smarter than this honorable court. Your lordship may have to understand the game plan. Your lordships will not permit this kind of attitude and approach, my lord, audacity by the concerned authority, whoever it may be. And he's being demonstrating in most of the cases. Your lordships have seen that. Has no respect for the rule of law. I'm only asking you lordships to have it day after tomorrow. I will seek amendment and then I'll let them come forward as to how this can be passed.
Time will not be before your lordships for arguing this case. I request your lordships will not close this case.
No.
Giving liberty to him.
No liberty. We don't require legal advice. I'm requesting my lordships to have it day after tomorrow. The only thing is now that 286 is day after tomorrow, my lord.
No, what I said, he has been working here. He is very congestion of the he was given, he was without posting for the past 2 years. He was waiting in one of the.
No, that all I'm not going into those merits now.
He has been working now. My client and his client went before the government. Government has taken a decision. Ego has been withdrawn by the government. By our Geo in December 386. Therefore, nothing surfaces.
All right, please come.
My grievance, my lord, may I just say this, Lord?
Please wait, Mr. Sudhir.
I'm only asking for day after tomorrow, my lord. Kindly appreciate.
The Leonard GP has submitted. Last is where is the docket number? On 31/10/2023. The Leonard GP, the services student, has filed a copy of the instructions received by him from the CCLA, the Commissioner Inspector General of Legislative Stamps, Telangana dated 31/10/2023, enclosing therewith copy of GORT number 386 dated 31/10/2023. The said GORT number, the first one, GORT number 275 dated 22/8/2023, and GORT number 279 dated 23/8/2023. And also to the interim orders of this court in IA number 1 of 2023 and WP number 24344 of 2023 dated 6/9/2023. In paras 4 and 5 of the section O, it's mentioned as under. The Leonard GP submitted that the GO under challenge in the presented commission is CO RT number 279 dated 23/8/2023. The same and make his submissions. Accordingly, matter is adjourned and it has been adjourned was adjourned to 1/11/23 and thereafter to 3/11/23 and again today. The Leonard GP reiterated his submissions that since the GO 279 has been closed and the he submitted that the issue is before the government for consideration. The Leonard counsel for the petitioner, however, sought further time to revise the prayer in the declaration, as according to him, he has not only challenged GORT number 279 dated 23/8/2023, but has also sought giving effect to GORT number 275 dated 22/8/2023. He submitted that by partially modifying GORT number 275 dated 22/8/2023, government is trying to surreptitiously do what it could not do by referring GORT number 279. He therefore seeks time to amend his prayer in the declaration. This court finds that though GORT number 279 dated 23/8/23 has been withdrawn by GORT number 386, the respondents have also partially modified GORT number 275 dated 22/8/23. Yes. Next.
Pass out matter.
After 2 days, if he wants to amend or he also wants to withdraw, fine, whatever.
Obliged. Lots of posted day after tomorrow, Bala.
I have posted it after 2 weeks, 2 days. So day after tomorrow.
Obliged. Keep you obliged.
GP wants next week. So what do you say?
No, my lord. It's my petition, my lord. I'm seeking. After I file, they may ask time. That's a different thing.
All right.
They cannot drag it on like this.
Yes, next.
So, matter number 74, Chandra GP for labor. H. Kumar.
Yes. Yes. What is the entry model? What is the entry model? ID order, your order of the tribunal. Unofficial response are raised disputes for the respond number 2 and upon said disputes without causing any notice to the the matter directly with the not in accordance with the matter is detailed examination. Okay.
But initially, like was
You are for the petitioner who is appearing for the for which response?
Official response.
6th onwards. Yes. Union as well as the employees. Commissioner of Labor? Anybody? GP? GP for Labor?
Respondent is
He is representing the 6th respondent as well as
appearing for respondents 7
not the union.
It's a response. Official response
is recognized. It's different. The recognized union respondent. Initially, complaint is given by one action of the people. But unrecognized union claim to be recognized. The recognized union is not the party because they also participated in the program. Page 28, what is the complaint?
What is the complaint means to?
But essentially, what they told the tenor of this complaint is that they have not been given promotions and increments. Because Lord, they have been targeted as being participating in the labor union.
Okay.
That's the page 28 is
Page 20.
On behalf of our union group, at the bottom, TSHC celebrity group. It's not any recognized union. The only one recognized union here is 6 respondent.
Registered number 1, what is that? It's not a registered union.
That's probably there. On behalf of our group, union group, we would like to point of our opinion to the management regarding few of our grievances for a second. Many of our active union members denied their right of union because of their trade union activities. At the same time, showing favoritism and the partiality to other union members regardless of merit. This action of management amounts to section 2 or unfair labor practices. And part of employer for using implementation of our union members. Hence, we request them changing GART classification, all your general in nature, denial of promotion, giving promotion without merit for 10% by method of optimization, regardless of merit. We request you to look into the advice to specify the above grievances and advise divide our union members without for fair both parties, establishing harmonious relations. That now, is the notice issued by
the Joint Commissioner.
While asking this particular reference is made. 14/6/2022. Representation. But this representation, they say we have given any representation to management. No details in that. There's only representation given. Since they have been working with this employee. asked us to attend the meeting and submit the remarks. Page 31. Remarks submitted by the institution. We have submitted detailed remarks. But essentially, we have four hours. Company does not retain any drawing. This set group set and what the doctor is enumerating group is not a restricted group of workers, not a then secondly, out of concern by the said group does not have classification in any of described under statute. There is no risk that the groups are apprehended in the application, and the representative not how many the date by all. It is not negotiable. Or any joint meeting at all. Then no aid, hardly related to government does not carry any of the trade within activities and have no quite represented that false misleading and suppress the fact. All the existing 404 workmen pay contributions to BSP company workers together, and we recognize only elected that is and his nominated call workmen only as trade union members. Then the fourth quarter. There is a categorical mention under factual standing order across the three, which states that promotion from class B to class A, from class A to clerical staff may be made at the sole discretion of company. Similar provision exists in long-term agreement dated 2016-2020, that the promotions are progress of maintenance, which are ending for reference to this demand. But these two documents lodged by NBC. But standing order is at page 55. So what is the norms followed by the parent? Page 53, page 55 is the, I just filed the relevant portion of the standing order across 3E.
Yes.
55 bottom.
Promotion
from class B to class A, from class A to clerical staff may be made at the sole discretion of company. Then look, the long-term agreement, the relevant clause, is at page 56, clause 14. Page 56. Assessment of workers' performance, promotion policy, acting policy. But this settlement is dated 26th July 2020. The lordship would get that at page 53.
53?
First page of that.
26 July 2020.
This is the one which is in force as This is the entered between the management and the recognized union. Coming back to 56. Management has inherent right to select workers for promotion or for acting in temporary vacancies by such methods as may be adopted by management from time to time. A. Promotions will take place to fill up shortages created at higher level job as per manning requirements and shall not be automated. B. All promotions are on skill merit basis. B. Promotions to mechanics selection will be made only from among the section in the position of IT certificate. The tradesmen who are currently placed in Mr. Electrician who in addition to their primary skills as desired by management shall be upgraded to technician at the discretion of management. The above terms and conditions shall continue effect from the date of signing of the settlement and will be enforced till they are substituted or modified by any other citizen. But this is the basis on which the promotions are increments are given. Essentially, any promotion is not it's an automatic, it's only based on performance and not their progress.
So the Joint Commission has taken cognizance of the complaint given by a trade union and has required you have submitted your explanation.
One more fact, because because we have mentioned that in our this remarks also. Lakshmi kindly come to page 33, coming back to the remarks submitted. Parallel. Page 30.
Yes.
We also wish to bring to your kind attention that all signatories to the reference to complaint were promoted multiple times since their date of appointment and given double increment for specific assigned performance during their tenure. For ease of reference, we have enclosed list of signatories, complainants of their present grades, gave a number of promotions which date with their current salary. Annexure 1. This categorically establishes the fact that there are no malpractice attributable against to the complainant by the company. Lord, this is at page 57. Lord, this annexure 1. That's why kindly see blood. Lord, employee 4 name, then department in which they are working, then date of joining, then joined in which grade and scale. Currently, they are in which grade and scale they are placed. Number of promotions received. Then last promoted date is mentioned, and then approximate gross weightage. If your lordship sees the number of promotions received, that particular column, almost everyone have received, have been promoted from one grade to another grade. Maximum 21, serial number 21 employee, he had been promoted 8 times.
9 times.
8 times. And serial number 15 and 16, 9 and also 18, 9 times. Therefore, this list was also furnished, saying that it is not the case that no promotions at all have been given to them. And we have also denied that
all these people are the petitioners, petitioners.
Yes, they are all the complainants. They say that they have not been given promotion. In the complaint you not have seen, no individuals or any specific reference is made as to what are the promotions, whether they have been granted any promotion or not, or any increments have been given to them or not. What are the promotions given to those who are other workmen who are working there? And in this page 33, we have also said at serial number 10 that they are not involved in any trade union activities. Page 10, para number 10.
Yes.
In instant case, none of the signatories to reference to complaint are involved in any trade union activities. Hence, unless the consequential denial of promotion because of their involvement in trade union activities does not arise at all. Then now, after this, but page 41, they ask us to learn number conciliation.
41. Yes.
Before submitting reports, I gave.
So what happened? The conciliation failed.
Then this failed. But the registered union also has given representation. But not page 44. That's the 6th correspondent in the present. Page 44.
Yes.
Kindly come to 45. Second two paras. When we are elected union, and the issues mentioned of issue of promotion that has been brought to you by certain individual workmen, they have to cause it illegal before authority of law. Basic representation of individual workmen because of by an elected trade union does not constitute in consultation with each and every individual workman. BST standing orders and LP are submitted and signed. Witnessed by your office, which is this year. When the issue of promotions and other general conditions are settled, it is not for certain individuals to take up the issue and make it an industry. This was the stand of this union joint commission. Then now we got page 15. The joint commission has submitted a report. That's also basing on that. Commissioner.
Refer the matter to the tribunal.
Commissioner is of the opinion that an industrial dispute exists between so and so. Respect of the matter specified in annexure appended to this order. Whereas the opinion of commissioner, it is necessary to refer dispute for adjudication.
Yes.
Let's page 51, this is the annexure. Whether management fails to grant increments from with a bias against so and so and granted undue favoritism towards other group of trades. But this order is not assigned.
So after this ID, you have challenged the reference to the ID, that's it.
Yes.
The tribunal has not yet passed anything.
Okay.
So
But
now
tribunal
this.
has not issued notice. Yeah, before your lord.
Hmm.
But this is essentially this order.
So how are you, on what ground are you challenging this?
Yes. But the formation of opinion. But if I can, but the judicial review with respect to the reference, this time but one day, bring to the logic to the.
Is there any other further procedure to be followed other than giving a notice for conciliation, receiving your
They received.
receipt?
They received my
And then
remarks.
thereafter they have to come to a
Of
conclusion.
their opinion. But whether this formation of opinion, Lord, is based on any material. Lord, whether there is an proper application of mind, but when they come to conclusion, that there exists a dispute. But that's not the point which you got to be considered. For that purpose, and there is one reference to right.
Yes, page 59.
59. When we come to paragraph 10.
Yes.
So it has been held that judicial review has to be for that. But it is very limited and short not aspect. Whether there is a material before them or they are not whether they have applied mind to that material what is there before. Before we proceed to the opposite question, it will be proper to discuss power of appropriate government in the sector of that in nothing or anything to refer disputes or activity. It's a peculiar position provided under the Act. Person cannot understand just directly for it. Except those cases falling under section 2 capital A, he has to seek the reference of disputes level. Section 7. Appropriate government has defined under section 3A, he is supposed to refer the thing. And then state that appropriate government may identify. It is of opinion that an industry dispute exists or is apprehended. Interpreting this section way back in year 1953, this court in state of Madras versus CP family stated following the position. Government should satisfy itself on the facts and circumstances brought to its notice in its subject to opinion that an industrial dispute exists or is apprehended. Actual existence of a dispute or its apprehension of making reference or government to decide. Order making a reference is an administrative act and is not a judicial or quasi-judicial act. Order of reference passed by government cannot be examined by the court in its to see if the government had material before it to support the conclusion and that dispute existed or was these proposals were based on unrelated act. It did not contain the words where appropriate government is public. Western India had government. One is an administrative function. This view that appropriate government is performing an administrative act or not judicial as part of even thereafter. The satisfaction of existence of an industrial dispute or the satisfaction that industrial dispute is the condition precedent to the order of reference. Order of reference cannot be made mechanically without forming an occasion. For formation of the necessary opinion, appropriate government must also be satisfied that the person who dispute is being referred for adjudication is the workman. If the dispute is not between an employer and his workman, it is not an industry dispute. Government can justifiably refuse to refer the dispute. From the material case before it, government reaches an administrative decision whether there exists an existing or amended dispute. In either event, it can exercise power under the system. The adequacy or sufficiency of material on which the evidence was not given. The action of the government in making the references by a party would be open to such a party that what was referred was not an industrial dispute and tried to refer. But if this was an industrial dispute, the practical existence of making a reference. But government could decide upon and not be competent for really because there was an opinion, no material before the government, on which it should have some kind of appropriate. When the appropriate government make a reference of industry dispute, only condition which the extent of that power should satisfy is that there should be the existence or apparent. Once government is satisfied of this question, it occurs to our condition to stress the formation of such opinion that there should be an existing or amendment industry dispute. The imperative and recitals of the existence or amendments of industry cannot recruit the court to exercise its power of judicial review and to determine whether in fact there was any material before the appropriate government. If there was, whether the government applied its mind in coming to conclusion that an industry dispute was an existence or was apprehended, but it was explained to make that. Therefore, an order of reference is open to judicial review. It is shown that appropriate government or it has not applied its mind to the material before it, or has not taken into consideration the vital facts which ought to have taken into consideration.
So,
the reference made to
it's para 17.
Para 17, Dr. Jeffrey. From aforesaid discussions, clearly follows that even when making a reference to appropriate government, is an administrative act. Before making such a reference, it has to form an opinion as to whether the industrial dispute exists or is apprehended. While forming this opinion, the appropriate government is supposed to take all relevant facts into consideration, touching upon this aspect. Power is not exercised properly, it is amenable to decision. Thus, where an industrial dispute exists or is apprehended, appropriate government review can be challenged in the court of law. Conversely, it is equal to if the reference is made, even when no dispute exists or is apprehended. This is equal to scope within which the court can examine whether the reference, whether the government while forming the opinion, subject to the formation of opinion, had considered the material which was placed before it, whether there was a proper application of claims by the government.
Okay. So in your case, what happened?
Because in my case, that's what. But
is there any other paragraph to be looked into in this resolution and the order? Is there anything any other?
That's only to that extent. The other
so, what grounds are you challenging your this one?
How my contention is that a complaint has been given by a non-union member, but they have raised a generic, made a statement that no promotions or increments are given because they were indulged in union activities. But the management has sent a reply when it was asked.
So you are saying complaint is not given by any employee?
Not registered for this issue, but this is a generic issue, which first of all, if at all it is an issue, it is a generic issue. What they have raised. Because no individual grievances are set out in the complaint, saying that I joined on so and so day, so I am entitled for a promotion, first promotion, second promotion, or third promotion from so and so grade to so and so grade. But nothing that sort is mentioned in the complaint. They only say that promotions or increments are not given. We have been victimized because we are participating in trade union activities.
Yes.
What are the trade union activities which they are participating? First of all, they are not even the
registered.
Yes. To which they are exposing this particular cost.
Then secondly, Lord, I have brought the joint commissioner was informed that the long-term agreement, the long-term agreement and the code standing order under practice describe what is the methodology or the basis for granting promotions development. So it clearly categorically says that it is not a matter of right and automatic.
Yes.
It is subject to the performance and their skills and the proficiency in the what they are discharging. Basing on that, and this agreement what is concluded between the management and the union, and it is binding on all workmen. Even if any of the workmen, there is a dissenting workman reference to any particular clause, still it is binding. Then most importantly, I have placed material before them at page 57 as an annexure to indicate that they have been granted multiple promotions over a period of time. And it is not a case that no promotion at all has been granted, as if they have portrayed or projected in the complaint. And there is not even a single complaint, except this first complaint which is given to the Joint Commissioner, 14/6/2022.
Yes.
In the entire of their service so far, if you actually see that statement once again, their date of appointments are mentioned. 93, 86, 96, 93, 85, 84, 2002, 96. So we got almost 1983, 84 also. We got 2002, page 57, column number.
Yes.
By date of joining. Till they made this complaint on 14/6/2022, not even there is a single complaint ever raised by them. Any they have produced any material to show that they have ever complained of saying that they have not been given promotions or increments as they expected.
Yes.
But when so much of material was placed before them, the requirement is formation of opinion. But if there is it's a case of there is no material at all, that's a completely different aspect. And so much of material is placed before them, before they gone, before the commissioner. Because commissioner exercises delegated powers are gone. The commissioner ought to have applied its mind. It's a complete case of non-application of mind. Coming to conclusion, to make a reference on this particular question, is also relevant here. It proceeds on the assumption that no promotions at all were granted. But the question page 51.
Whether the management failed to grant increments and promotion with a bias in his undue favoritism towards the other group of the trade union.
That he should have some material. What are the promotions already given to other group at all, first of all? For him to, if he is comparing with one person with the other person.
Yes.
And their complaint is that no promotions at all were granted, but still we have produced some material or whatever the records available with us to show that they have been given promotion, that they have been promoted from multiple times, more than 2 to 9 times. Then who are the others? What they are referring to? No details are given. Then they say that they are indulged in union activity. Where is the material? There is no material to show that they are involving in union activity. And in fact, emphatically, we have said in our remarks that these persons are not at all involved in any trade union activities. And the recognized trade union and comes and submits their remarks saying that we are the recognized trade union. There is a long-term agreement which is in place. If at all any issue has to be raised, it is we who are supposed to, they are supposed to raise that.
So the other group also has given a letter before reference is made.
Yes, sir. That is at page 44, dated 12/9/2022. The reference order is 4/11/2022.
Sorry. Page number?
Page 44. Page 44. 12/9/2022. Relevant paras 45.
Yes.
Last but one paragraph 45. There no issues of property that has come up.
So he did not apply his mind and he's not given the details of the person to whom favoritism has been.
That document applied his mind in perspective. First of all, it could have compared whether at all these people have been given promotions or not. If there is some material already placed, then whom are they talking about who have been given promotion? Those details are not given. They have not produced any such details. So they proceed that they are trying to proceed on some assumption. And now they say that they are indulging in union activity. When we said no, they are not indulging in any union activity. So what is the material on which they say that they are indulging in union activities for them to be victimized? But all these circumstances to demonstrate that though there was sufficient material, that material was not considered. And the material which was not before it has been taken into consideration.
What is that other material taken?
Which is not there, means they are comparing with some other departments' promotions. That's in 8. They have not produced any of that information. But we don't know whether or not there are any others who have been given promotions more than what they or the promotions more than what they are entitled to. But again, this is all subject to. So prima facie, they are not saying that whether they are entitled for promotion, what is the performance they have achieved. So that's all subject to that various aspects of their workmanship. But for minimum requirement is that there should be some material. But that material is not there.
Now, counter affidavit is filed by response 7/12.
Yes.
Respondent number 3 also has filed. Respondent number 3 has filed a counter. Mr. Zakir Ali Danish has filed a counter. Who is respondent number 3? Joint Commissioner of Labour.
Joint Commissioner.
He has filed a counter. Mr. K. Venu Madhav has received it. Look at from your office as well.
వచ్చింది 981 981 తక్కువ వచ్చింది.
अच्छा मेरे So only unofficial respondents have filed a counter. Yes.
For that legal party. What I would like to take note of this union. One is a recognized union recognized union and the others, there are many unions in the industry. Only one will be recognized union and other will be registered union. But I am a registered union. But it's like this. Now BJP is a recognized union, recognized party, and Congress is registered. It's like this. But I can raise now the petitioners before your lordship can raise the dispute. It's an industrial dispute under section 2K of IDA. Only registered, recognized unions should raise the dispute is not correct here. Any union, any workman who is aggrieved by the action of the management can raise the dispute. Section 2K. But that's the case here. But here also, some of the employees from the registered union, but in fact, here registered number is also there, your lordship. Page number 30. Representation of Mr. G. Nagesh and 21 others, in brackets, Dr. G. Sanjeev Reddy Group, EST Workers Union, registered number 1. I am registered, but I have a right to agitate my issues against the management before the Labour Department. Therefore, I gave a complaint to the respondent, the Labour Department, stating that there are irregularities in promotions and not granted increments, and the management is acting at their whims and fancies without following the procedure. This is the complaint. That's nothing but an unfair labor. Okay. That matter was taken up by the conciliation officer, but the duties of the conciliation officer are very limited. The conciliation officer issued a notice basic upon my complaint. The management appeared, they filed the reply. As there was no amicable settlement between the parties, the matter was admitted in conciliation. And then, now the duties of the conciliation officer or the deputy commissioner officer or deputy commissioner is very limited. He cannot go into the merits of the case. He cannot, in fact, his own judgment not speak so. It's only an administrative order he has to pass. He sent the failure report to the government. In turn, the government referred the matter to the tribunal for adjudication of the dispute. Yes. And the notice has been issued by the Labour Court. There, the reference was numbered, ID number, and then the notice was issued. That notice is unchallenged before the court. Now, what are the grievances? Now, before the Labour Court, I have to file my claim petition, my grievances, along with the documentary evidence. They will file the counter. Then I have to adduce the evidence. What are my grievances and the procedure what they are following in respect to promoting the so-called employees. Then the award will be passed. That is the finality of this particular reference. Now your lordship is treating the present case. The Deputy Commissioner of Labour has rightly referred the matter as it is administrative action.
Yes.
In these conciliation applications, I should not disclose or I should not detail the who has to be promoted, how has to be promoted, what are the grievances. It's only a conciliation application. Conciliation application is to a precise to informing the Deputy Commissioner of Labour in respect to what are the grievances. That's all. It is my duty to put forth my documentary evidence or whatever the evidence before the tribunal in the form of writing, in the form of documents. Then the matter will be judicially adjudicated.
Which section of the Industrial Act describes or prescribes the duties of the
Yes, conciliation officer, your lordship. Mirror section 10, mirror is there. Section mirror 1 means that mirror section 10. The idea.
It is under section 10, a reference can be made.
Yes.
The subsections of 10 only deal with the.
Yes, yes. To refer the dispute, matter, one thing. And one more thing is the duties of the conciliation officer is also there. Okay. And the rules it's there here.
Reference of disputes to boards, courts.
Yes.
Yes.
About under section 11 of the ID Act, Your Worship.
Section 11.
Procedure and powers of conciliation officer, so and so, Your Worship.
Yes.
This is the procedure, my lord, what diagram.
Yes.
May I read first 2-3 points? Procedure is given, my lord. A conciliation officer or the member of the board or presiding officer of the labor court may, for the purpose of inquiry into any existing or apprehending interesting dispute, after giving reasonable notice, enter the premises occupied by any establishment to which the dispute relates. Not section 11 up to 7, Your Lordship, it's there, Your Lordship. And one more important point, Your Lordship, 11.6. All conciliation officers, members of the board of the court and presiding officer of the labor court, tribunal shall be deemed to be a public servant within the meaning of section 21. What is it? And now, Your Lordship, please to see that section 10 comes into play. Not here, not wherever the appropriate government, not the failure report will be sent by the conciliation officer to the government, and in turn the government will refer the matter to the concerned labor court for adjudication. And what is the role, my lord? In fact, the learned friend has filed the citation, Your Lordship. That citation itself clearly demonstrates. Not at page number 80, Your Lordship, of part of judgment.
Yes.
Page number 80, not 42 paragraph. I'll read it.
Yes.
An industrial dispute has to be referred by the appropriate government for adjudication, and the workman cannot approach the labor court or industrial tribunal directly, except in those cases which are covered by section 2A of the Act. The reference is made under section 10 of the Act in those cases where the appropriate government forms an opinion that any industrial dispute exists or it appears. The word industrial dispute exists are of paramount importance. Unless there is an existence of an industrial dispute or the dispute is apprehended or in the appearance such as industrial dispute may arise in the future, no reference is to be made. Thus, existence or appearance of industrial dispute is essential for making reference. No doubt, at the time of taking decision whether the reference is to be made or not, the appropriate government is not to go into the merits of the dispute. Making a reference is only an administrative function. At the same time, on the basis of the material on record, satisfaction of the existence of the industrial dispute or the apprehension of the legal such existence, apprehension of the industrial dispute thus becomes a condition to stay, though it will be only subject to satisfaction based on material on record. Since we are not concerned with the satisfaction dealing with the cases where there is apprehension, industrial dispute discussing the following to confined to existence of industrial. So my submission for your lordship is it is only an administrative action of the government to send the dispute. The documents or the evidence will not be before the government. It is before the tribunal. It is the duty of the tribunal to take care of all those things and to pass an appropriate order. All the grounds raised by my learned friend, Lord, in the present petition are to be considered by the tribunal, but not under 226. And this particular citation, Your Lordship appears to say, it is regarding a claim of an employee who was terminated around 14 years back. So he raised the dispute with a delay of 14 years.
Yes.
But on that particular ground itself, this was allowed. But the last 82, page number 82, 55. On the application of the foresight principle of the fact that the present case, we are of the view that the High Court correctly decided the issue holding the reference as such a belated stage after 14 years of termination without any explanation for delay in approaching the appropriate government. But this particular issue is raised by an individual workman who was terminated, and after 14 years, not approached the court. Therefore, court said it's a related case. But this is one issue. But the second, your lordship is to see here, respondent, another recognized union also. Once there, I did not make the party before the conciliation officer. I made only management as a party. He filed that this clearly demonstrates that they are colluded. Repeatedly because they are colluded because there is dispute. What is the interest he has in not granting promoting me here also? The role here this clearly demonstrates here also. There is no role to play for that particular recognized union. And even if the matter is referred, now the matter is referred, the recognized union is not a party. Party is my manager.
Yes.
That's so therefore my submission before your lordship is this petition is a premature petition. Where the issues, what the issues have been raised by the petitioner are to be adjudicated by the labor court in this particular reference based upon the evidence. Therefore, it has to be dismissed.
Yes.
One more judgment, Lord. (2009) 11 STC 609. In this also, government refused to refer the matter. Challenging that particular issue, the petition is filed. And the court directed the government to refer the matter, and which has to be executed by the tribunal. Para number 36 here or page number 623. This is the para 623. Para 36.
Yes.
By exercising the powers of section 10(1) of the Act, the functions of the appropriate government is an administrative function and not a judicial or quasi-judicial function. In performing this administrative function, the government cannot devolve into the merits of the dispute and take upon itself the determination of the list, which would certainly be the excess of the powers conferred on it by section 10 of the Act. However, there may be exceptional cases in which the state government may, on the proper examination of the demand, come to the conclusion that the demands are neither perverse or favorable and do not merit a reference. But the government should be very slow to attempt an examination of the demand with a view to declining the reference, and the court will always be vigilant whenever the government attempts to use the power of the tribunal for execution of the valid dispute. And to allow the government to do so, we under section 10 and 12(5) of the Act.
Okay.
Next paragraph. Where in the instant case, the dispute is whether the person raising the dispute are workmen or not, the same are to be decided by the government in excess of its administrative function in section 10(1). The dispute was whether the drivers were employees or not of telecom. That is to say, whether there was any relationship of employer and employee between so and so and so. The Deputy Commissioner of Labour or the state government was not justified in holding that the not workmen and accordingly no reasons to be made. This is my submission is the government or the Deputy Commissioner can't decide the issue. It is for the tribunal basing upon that.
what has been stated by. When the reference order is the other union has come up. They have also got the notice of that. This is not any huge issue what has been raised. They are saying somebody has been given somebody. In that context, there is not to be anything. The other one, the social aspect is the formation of opinion. Like the something of the formation of, but I may have another opportunity of participating in the assessment procedure. But like here, before the ID code, but that will not because my right or the duty of the government. I mean, opinion, subject formation of opinion. But every case, it's a mechanical thing, otherwise that's not how. You have simply said that whatever report is submitted by the joint commissioner, government will basing on that report they would send it to the tribunal. There need not be another midway government's intervention there. Whole of government there is not again like government has to form an opinion. But one question of opinion whether the material has been considered or not, will have to be called out from the what is there now.
I'll consider. Third reserved. Since the marriage is third, the others are reserved. Next of models from the max adjustment.
Extension of interim max. Number 89. Rahul Reddy, Chief of Medical Examiner.
Contents are not filed. Something appeared in the morning when opposing. Counters is to be passed in the file is dispatched. New system, entry model list after who is appearing for the respondents here? TSHC is not here. Civic type is consulted. Entry model and extend.
98. Jila Srinivas Reddy, Chief of Revenue, Chief of Irrigation Command Area.
The request of the energy shall contract is after 3 weeks. Model standard industrial standards. That's the last week. Yes.
Item number 112. Linga Rao, Kadi Praveen Kumar, Mahendra Rao.
Models with regard to the cancellation of regulation of the system. After the internal they have been subjected to services that they have been working since 30 years. In the regional engineering college, they have been converted into the national during the year 2007.
So when were their services regularized? Appointment has been cancelled now.
Yes. Appointments are illegal, therefore they were cancelled.
So when were the appointments given?
Now the appointment is cancelled
in this year only, June 23.
Page 83, page 83.
Yes.
Not what?
Yes, yes.
Now
So This is
The
a
applications are invited.
Ah,
And they select the person who are, there were 95% who have been working since 30 years. The board of governors have taken the decision, a policy decision to select, to appoint on regular basis. Because of it is a mandate of the policy of the government of India, that is 10 lakhs of the vacancies has to be filled up. It is pending under the acting control of the central government and it's a valid instrument of it. That application, the policy decision board of governors and passes the resolution. Taking into consideration millet with regard to the millet, now to fill up the vacancies.
So this will take some time.
Not to be carried.
This will take some time, we'll take up tomorrow. I think now only 10 minutes, we may not be able to conclude.
No,
We'll take up tomorrow.
Congress are required to extend it.
I'll extend it till tomorrow, I'll take it up tomorrow.
This opposition is concerned, even at the time of admission, this distorted and the.
Whatever, now that the stay vacant, see,
Even at the mentioning minute the stay, I don't understand, my colleague has informed, he is opposing at the everything. But I don't understand this kind of.
Sir.
Now, he says illegality, I don't know what is.
You will both, please maintain, please. There is, once a stay vacant petition has been filed, it will not be heard unless time is not there. Now there is no time. I'm posting it to tomorrow, I'll extend the time till tomorrow. Both of you argue the matter.
Yes. No, I'm not.
The stay vacant petition will be decided or the.
Now I filed a reply, he filed a counter. You not to discuss the matter.
Yes, tomorrow. The entry model granted earlier shall stand extended till then. Okay, yes.
Till tomorrow.
Till tomorrow.
Item number 124, A.K. Jayaprakash Rao, Chief of Labor.
Sort is not filed. No, sort is not filed, no.
ఒకదానికి లెఫ్ట్ వితౌట్ ఇన్స్ట్రక్షన్స్ రెండు అడ్రస్ సెకండ్ రెస్పాండ్ అంజయ్ రెస్పాండ్ నెంబర్ 1 కి
Not left without instructions. So left without instructions.
రెండు ఇన్స్ట్రక్షన్స్ వితౌట్ ఇన్స్ట్రక్షన్స్ రెస్పాండ్ అంజయ్ భవన్ గారికి కాకుండా నేను ఒకటేం జనరల్ సెక్రటరీ మెస్కో వేశారు ఇంకోటి బై నేమ్ మెస్కో వేశారు జావేద్ అఖ్తర్ అంటే పేరు టాలీ
MESCO Staff Association.
స్టాఫ్
Sir, you have
పార్టీ
taken
కాదు
notices. So, one is the Commissioner of Labor.
కమిషనర్ టూ గురించి
That is, no, and for that you have not taken out notice. But for two, respond number two notices they have taken out.
Yes, sir. What is
One is in the name of individual.
He is an employee who before the labor code, who is a party union and responsible the class.
So he has left without instructions. Both have said.
Association and the individual.
So the association address is not there now, MESCO. You are the management.
అసోసియేషన్ ఆర్డర్స్
Management of MESCO College of Pharmacy is the petitioner.
General Secretary, MESCO Staff Association.
So staff would still be there and there would be an association. How can it be that, they have left without
పార్టీ లేదు మేడం అసోసియేషన్ పార్టీ లేదు
MESCO Staff
General
Association,
Secretary.
General Secretary of the MESCO Staff Association. Staff Association is ఉంటుంది కదా, అది ఎక్కడ పోతుంది? So you will have to find out the correct address and then serve.
That is the address which they have given.
Who has given?
The union which they have.
When did they give? Where did they give?
Claim statement, madam. The claim statement filed before the.
After that, they might have changed their address.
Staff Association, they have. But here.
We do not know, sir, but here the notices have come back saying that no left without instructions.
Yes, sir.
Now, if the writ petition is to be heard and allowed, then notices will have to go to them.
You are not again once again.
We can take out fresh notice, find out what is the correct address,
Yes.
and then thereafter take out notice.
Yeah.
The Leonard Johnson for the petitioner seeks time to get the correct address. time to get the correct address.
Yes, sir.
Furnish it, then I'll permit you to take out personal notice.
Yes, sir.
Now I have extended the inflow. You first serve the notice on it. Not like that. Sir, you are also a lawyer for the employees many a times. So let the notice, no. Let the notice go to them, then it can be extended. After service of notice also, if they don't come, then I'll extend it after further notice.
They don't receive help from errors.
Sir, addressee left, left without instructions, we do not know. Get the correct address, try to take out notice. Once it is served and still they don't appear, then it will be granted until further orders. Not like this. Yes. Just after 2 weeks, yes. 20th November. Yes. That's all. Call it. Next, please.
Continuation of this, item number 82, Ravi Chandrasekhar, Chief Coroner, Chief for the Revenue.
Yeah. You want after? On register. On the follow. Okay, after. Register.
Number 83, Gopal Ramarao, Chief Coroner.
Actually, I think very recently filed an immediate petition. That was not filed when I was there.
Next week, next Monday.
Incident, immediate petition filed.
Oh, that will be difficult. I think Monday based Monday. Even the other one, 82 also Monday. 82, Mr. Ravi. Please inform us, somebody here. It will be Monday, next week.
Item number 84, Uday, Chief of Home.
What is this IA for?
IA for an order of
Other cases may not be qualified and eligible, but they are not considered because of the reservations and all. The two directions given to consider the case in the existing, but here the petition itself is working as industry report. Not an advocate, not in the rules.
This is the APP work.
APP must be an advocate.
Yes.
Rejected by case on the grounds that I was not actively practicing.
Where is it? Are you a lawyer? Are you an advocate?
Yes, you know.
Where have you filed the enrollment certificate and all?
So he was a lawyer there.
He was a lawyer at that.
Subsequently, got it in government service and
That is the entire issue that was considered by your.
because he's not an advocate, he's not eligible to be considered.
That person, no. In the other case, I remember, right? He was working as a law officer in another. Whereas here. No. Presently, when he made an application, he was not practicing here, but he was practicing elsewhere, or he was practicing as a law officer in another organization.
Not practicing criminal code.
All right, you file. How much time?
3 weeks.
2 weeks. Monday week.
Item number 85, Amarnath, David Ramarao.
Rejected by the respondent before.
You have applied for reversion.
Reverse. I start an application for rejection, this for reverting to missing.
What is the reason for seeking reversion?
Family, just to take care of his father and also at the time he has to take care of family. Reasons for taking you go to post 28 of the Telangana State schools where he last
In
similar circumstances, not some choking others.
These are peculiar types of cases. We want permanent solution.
In this case.
Case project.
Yes.
Yeah, here.
And he said he's not never going to ask for promotion again.
This particular case is also.
But here we are,
Currently saying.
no, this issue is already for June 28 and the issue is concerned. They not made. TSHC. This court considered the issue and rejected. This is a repetition. The appeal is filed, that is pending. But that was also the energy request to discuss the repetition that apparent council sought for action. This is though factors like a different minute, but the principle is same. June 28 is considered. This case, it's a 15th battalion, it's actually tribal battalion. There, they said that initially they were accepted promotion because there is no conversion to it's a tax. Subsequently, conversion provision is given, therefore, they may be considered for reversion. Document kindly put, there are 7 onwards.
Are you aware of this judgment? You're not aware. Go through it.
Yes.
And then next Monday.
Item number 90, GP services.
Lord, this you lots have heard. Lord, 5 charge memos, Lord, last 10 years they are keeping it pending. And Lord, out of the 5 charge memos, inquiries were over in 2 and then in 3.
Take up tomorrow. Continue.
Much obliged.
No, I'll take up in the daily list unless until there is urgency in the matter. I'm not going to prepone because the daily list will continue every day. Can you please maintain some room here? One after the other, please. 120? What do you want?
The other question for inspection is not given by I guess
I'm telling you, the daily list will only be going up. It's not going to go out of the list tomorrow. Today I have already heard up to 89. So tomorrow onwards, 90 onwards will be coming up. Okay, if any additions will be only in the motion list and additional adjourned motion list. Nothing in the daily list, no additions. So they'll only be going up. So please don't ask for this preponement of your cases. They will come.
I just 94 minute, it is a fresh admission, partially it was listed in the daily minute. Tomorrow is adjourned.
Student, verify change. It is the first of fresh admission and so, sir,
Admission projects are given Monday.
Consideration.
tomorrow adjourn motion.
Okay.
So they'll come next week, no problem. Extension of interim orders is necessary. You have filed a vacate petition. That will be heard next week, next Monday. Now it will come immediately after the adjourn motion list, your map only will be there tomorrow. What is the problem?
you.